All right, we're here today for a review. And Mr. Anderson has
Yes.
provided with his assessment, which I'm very happy to see.
Yes, Your Honor. Mr. Adams also tells me he's completed 1 day of community service and will complete 2 additional days prior to its next court date.
Sounds good. How are you feeling about being at this point then, Mr. Anderson?
What's that?
How are you feeling about how things are going at this point?
Good. I'm not having any problems.
Mhm. All right, Mr. Anderson, we'll see you back here in 90 days. That's gonna put you on October 23rd at 10 o'clock a.m., okay?
Okay.
Please continue to work on everything that we have discussing and that your probation is requesting. We appreciate you working on it, Mr. Anderson.
Thank you very much, Your Honor.
Take care, sir.
Thanks.
Call the case of the state of Michigan. First, Mark Capaldi, case number 23 FB 1508.
Any Woods for the people. Your Honor, or sorry, Allison Mueller here on behalf of Mark Capaldi. Mr. Capaldi, could you please state your name?
Mark Baldy.
Thank you. We're here for a violation of probation.
Yes, Your Honor, could I briefly approach?
Sure.
Yes, Your Honor, we are requesting an adjournment to go over discovery and continue plea negotiations.
And Judge, it appears I received a community corrections report that he's testing positive for THC. There's no record of a medical marijuana card or letter of necessity on record, and he also missed 2 SoberLink tests.
May I
Thank
speak?
No. All right, the pretrial in this matter is going to be adjourned in this particular case to August 28th at 9 o'clock a.m. As far as the progress report that we received is concerned, they haven't chosen to violate him on that yet. The prosecutor is indicating that you have tested positive for THC on 2 separate occasions, and that you have been, one time you were late testing and didn't test until 4:13 p.m. And then the next 2 times on July 3rd and July 11th. No, just one time you didn't test. The other 2 times you tested late. And at one of those times you tested 6 hours late. So one time 4 hours late, the next time 6 hours late. And then on July 3rd, you didn't test at all. So, as far as the THC is concerned, this court has not given you permission to use marijuana, sir.
I given the corrections officer my TAC card, so I don't know.
As I just indicated, this court has not given you permission to use marijuana.
Oh, I didn't know that's how I operate. I thought if I had my card, I was good.
It doesn't. It doesn't. You have to have a letter of necessity in order for this court to decide whether or not you're going to use marijuana.
Yes, Your Honor.
You have a letter of necessity, you need to stop using marijuana until you get one and this court approves it. Okay?
Yes, Your Honor.
Why is your client testing late?
Your Honor, I'm stepping in for this matter. I'm not sure if Mr. Gore and Mr. Mansour talked about the missed test, but Mr. Gore, if you can indicate to the court why you have missed Soberling tests, then that would be helpful.
The missed test was the day I had got out for a probation violation, and I believe I just slipped my mind after I had got out. I had court the same day. As for the late violations, they were honest mistakes. I worked the night, and when I woke up and realized I didn't take them, I took them because I figured it would be better for a late test than no test.
Well, sir, if you if you don't test again, I'm gonna violate your bond and your bond could be revoked. Do you understand, sir?
Yes, Your Honor.
I'll see you back here on August 28th.
Thank you, Your Honor.
Are we ready to recall the Tyler Hagedorn matter now?
Yes, Your Honor.
What will recall the case of the state of Michigan versus Tyler Hagedorn, case number 25F00113.
Tiffany Woods for the people.
This is Commander Davi Liebman. We have Mr. Hagedorn. Mr. Hagedorn, could you say your name, sir?
Tyler Hagedorn.
Thank you. All right, Mr. Lebo, you had a chance to talk to your client about whether or not he wants to proceed with a non-jury trial?
Yes, ready to discuss Mr. Hagedorn, the option of a bench trial, as well as the prosecutor's plea agreement and the benefits of 4A, as well as the prosecutor's indication that she would not object to being released from custody if he were to accept that offer. Mr. Hagedorn has indicated to me that he would like to reject that offer and accept this matter for the earliest available bench trial. Is that correct, Mr. Hagedorn?
Yes.
All right. The first available bench trial so that he can make an informed choice is going to be on August 12th. Is that
Well, Mr.
still?
Hagedorn.
Go ahead.
So, Mr. Hagedorn, that would be in about 3 weeks.
Is that still what you want to do, Mr. Hagedorn?
Yes, ma'am.
Do the people waive their right to a jury trial in this particular case?
Yes, Judge.
Non-jury trial will be scheduled for August 12th, 2025 at 2 p.m. Mr.
And
Hagedorn,
Judge, since I just wanted to note to the court that if there's any issues with unavailable witnesses, I will be sure to email the court right away to have that date changed if there's any issues. Thank you.
If Mr. Hagedorn is going to remain in custody, I would object to any adjournment of that date.
thank you. All right. What I'm gonna do is do exactly what I did before, which was so he can be released to inpatient treatment. Did you talk to inmate services about getting you into an inpatient program, Mr. Hagedorn?
I tried, but they put me in a pod where there was no CO most of the time. So I can't talk to anybody and I'm confined. I'm in a PC, personal confinement.
Okay, that's weird.
But I'd like to go to rehabilitation. I mean, I don't know. I have an alcohol problem and I'm sorry for saying I didn't last time. I just wasn't ready to admit it yet.
I understand. Mr. Lebo, Do you have other staff there other than Mr. Works who might be able to make a call over to inmate services? Because he really should get the process going to get into treatment.
I can make that call, Your Honor.
All right, thank you. All right, the bond will continue with you being released to treatment as soon as the bed is available, sir. I will allow that for you, okay?
Thank you very much, Judge Washington.
You're welcome, sir. All right, I'll
I'll
see
send an
you.
email to Mr. Noctree.
All right. Oh, you're sending an email right now. Thank you
Yeah,
so
to
much.
Mr. Noctree. No problem.
Thank you. Mr. Noctree is in inmate services and he will take care of this for you. Mr. Hagedorn, okay?
Okay.
All right, thank you. We'll see you on August 12th.
All right, thank you.
The court will call the case of the state of Michigan versus Ashley Shoemaker, case number 25 S0017.
Tiffany Woods for the people.
Allison Muller here on behalf of Ashley Shoemaker. Ms. Shoemaker, can you go ahead and state your name?
Ashley Shoemaker.
Thank you. Good morning, Ms. Shoemaker. We're here for a pretrial today.
Yes.
Yes, Your Honor. We are requesting an adjournment today to allow Ms. Shoemaker to get an alcohol assessment. And Your Honor, there is one part of bond that I would like to address if possible.
All right, you may proceed.
Thank you, Your Honor. Ms. Shoemaker is on a sober link. I believe she's also doing random testing. This underlying offense only involves alcohol. So if the court would consider allowing her to remain on the sober link and remove the random testing, then that would be our request.
Judge, her BAC was 0.190 and she also had a THC of 4.4 nanograms. So drugs and alcohol were involved in this. Thank you.
Oh, there was marijuana. Okay. I apologize, Your Honor.
It's okay. Bond will continue. You're all set, Mr. Maker. You need to continue testing as ordered. You had marijuana in your system and alcohol when you were driving and during this allegation. We'll see you back here.
Okay. I have a medical marijuana card. Is there any way that I can get some type of letter from my doctor?
Ms. Shoemaker, why don't I give you a call after court and we can discuss that process, okay? Is that okay?
Okay. Yeah. Thank you.
Thank you, Judge. We'll discuss that.
Thank you.
And I will advise her that it's ordered to be discontinued as of now, or has been the entire time.
Yes, and as you know, her having marijuana in her system while she was driving with alcohol in her system is a violation of the MMA, and she's not entitled to
Yes.
use marijuana. All right, thank you.
Thank you.
Judge, I happen to miss the next pretrial date for this case. Is there any way you could repeat the date for me?
August 28th,
Thank you, Judge.
9 o'clock. Maybe I never said it out loud, is what I'm being told. So it wasn't your fault. August 28th at 9 a.m. is the next hearing. We'll see everybody then.
Thanks, Judge.
Thank you. The court will call the case of the state of Michigan versus Derek Riles, 25S00242.
Tiffany Woods for the people.
Listen, public defender Davi Lebo for Ms. Riles. Ms. Riles, could you unmute and state your name, ma'am?
Derek Rouse.
Thank you. All right, we're here for a pretrial today.
Yes, we're going to be requesting an adjournment so that Ms. Riles can complete a substance use assessment.
Thank you.
And Ms.
Judge-
Riles, I did provide you the contact information for that, correct?
I was actually going to give you a call. I didn't see that in my email when I checked yesterday and then again this morning.
Okay, please give me a call after court about that.
Okay, thank you.
And Judge, there was a community corrections report that came out that the defendant is testing late almost every single time with all of the tests. And I know that she had an OWI BAC of 0.227 and was passed out behind the wheel. So we are concerned that there may be some sort of alcohol issue going on, which is why there's these repeated late tests almost every single time, Judge. So we do have concerns about that.
All right, to discuss it with Ms. Riles, what she indicated to me is that she's had some trouble testing timely due to her work schedule. She works overnight. I did explain to her that it's very important that she needs to test on time, that the court may consider that indication for drinking if she does not test on time. She has assured me that she is not drinking and will not have any further late tests.
Mhm. Her word as to whether or not she's drinking is not going to be good enough. That is why we have her testing at particular times. Ms. Riles, you need to test timely. Another violation after today would be considered a violation of your bond, and your bond can be revoked. Do we have an understanding on that?
Yes, Your Honor.
All right, thank you. I'll see you back here on this. Why were we adjourning this one? I don't remember.
For a substance assessment, Your Honor.
Then August 28th, 2025 at 9:00 a.m. The bond
Your Honor, was
will
that the
be
28th?
correct, August 28th.
Thank you.
We will see you on the 28th, Ms. Riles. Have a good day.
You as well. Thank you.
State of Michigan versus Kiera Adams, case number 25S00170.
Tiffany Woods for the people.
Assistant Public Defender Davi Lebo for Ms. Adams. Ms. Adams, could you state your name, ma'am?
Kiera Adams.
Thank you. We're here today for a pretrial as well as a bond violation. We received a bond violation report on this particular case.
Your Honor, my apologies, I did miss the bond violation. If I could just briefly speak to Ms. Adams.
You may.
Thank you.
I will pass this now. Well, we'll call the matters of Tierra Sneary, case numbers 17S00053 and 19S00713.
Tiffany Woods for the people.
Allison Muller here on behalf of Tierra Sneary. Ms. Sneary, can you state your name, please?
Sierra Sneary.
Thank you. We are for pretrials in both of these matters.
Yes, Your Honor. I'm sorry, Your Honor. We are requesting an adjournment, it looks like, to continue negotiations on the matter. And I do believe Ms. Sneary and Mr. Mansour discussed bond, and I'd like to address that if possible.
Thank you. May I proceed?
Thank you, Your Honor. And I'm sorry, I don't have the police report pulled up, so I do hope this is correct here, but I'm asking to remove drug testing. Both cases, I believe, involved only alcohol. I will pull that up and double check. But if that is the case, then we're requesting her to remain on sober link.
Whenever you're ready, Ms. Woods.
Yes, Judge, I was just looking through both cases quickly just to make sure I didn't forget anything. I believe both of these cases just involve alcohol, Judge. I'm not seeing any positive test results for drugs or that drugs were alleged in any of the reports. Thank you.
All right. Based on that, I will remove the drug testing components and she can continue testing on the sober link.
And just to let the court know, Judge, I did receive a assessment on this defendant this morning from Mr. Mansour. So I just need some time to review that assessment in the case. I just wanted to keep the court updated on that. I'm not sure if Ms. Moeller was aware of that.
Thank you.
Thank you.
And Your Honor, if I could just ask a clarifying question, I believe Ms. Sneary is drug testing. She's also ETG testing 1 time a week in addition to the SoberLink. Will the ETG testing remain?
I believe that that's the community correction decision. They have decided that she's ETG testing. So as far as I'm concerned, it's whatever they decide. There must be- They want that. I'm just ordering that the SoberLink continue. If they decide they want to have an ETG in addition to that, then that's what they're gonna do.
Okay, thank you.
Do we need, I can bring you back on August 14th or August 28th?
Stephanie.
Which would you prefer, Miss Neri?
Oh, the 14th fine.
And you'll be ready by then, Miss Woods?
Yes, Judge.
August 14th, 2025 at 9 a.m. Fine, is continued as we just discussed.
Okay. Do I still go to community corrections or do I just do the SoberLink or do I have to talk to somebody?
You're gonna be doing the SoberLink. You should talk to them about whether they still want to do the ETG or not, but I'm just ordering the SoberLink. It's up
Okay.
to, I'm gonna continue with the ETGs.
Okay, thank you. Miss Moeller, can I have a second with Miss Moeller?
I don't know if you can do that right now. I think she's the only, PD
Okay, that's okay.
Ms. Sneary,
Okay.
I'll give you a call or give our office a call maybe
Yeah.
after 1 p.m.
Okay.
You
All
can
right.
go. Miss Neri, 1 second.
Oh, sorry.
Mr. Lebo is here. You can go in with her if you want to.
Thank you.
And Kiera Adams is Mr. Lebo's anyway.
Correct.
The court will call the case of the state of Michigan versus Kiera Adams. It's a recall, actually. 25S00170.
Tiffany Woods for the people.
Assistant Public Defender Duffy, Lebo for Ms. Adams. Ms. Adams, can you say your name now?
Kiera Adams.
Thank you.
And you're
All
going
right.
to discuss the bond violations with Ms. Adams. She'll admit to the violation and she does have an explanation.
Ms. Adams, the bond violation indicates that you had the following non-compliant events on your SoberLink: that you missed the scheduled test between 6 a.m. and 9 a.m. and didn't submit a compliant test until 11:34. And then you missed the scheduled test between 9 p.m. and 12 a.m. and didn't submit a compliant test until 2:17 a.m. And then you missed the scheduled test between 6 a.m. and 9 a.m. on July 14th and didn't submit a scheduled test until 10:49 a.m. I'm curious as to how they decide which is a violation and which is a progress report, but that is what we got.
And I can't answer that question, Your Honor.
Yeah. All right. And ma'am, it's my understanding you're going to admit that you violated in those ways?
Yes, I violated.
All right, please raise your right hand. Do you swear or affirm that the testimony you're providing is the truth, the whole truth, and nothing but the truth?
Yes.
And I'll accept that as an admission to the violation. Are you satisfied, Ms. Woods?
Yes, Judge.
With Your Honor.
All right, and what's the explanation, please?
Your Honor, Ms. Adams indicates to me that she's working. She is also a single mother of multiple children, and that she's also juggling her drug testing, and that with that she's had some difficulty keeping these things organized in her mind, remembering to do SoberLink timely. I've explained to her it's very important she does the SoberLink timely, that she should set an alarm on her phone to make sure she does it. She tells me she is going to do that, and that she does not anticipate any more violations.
Thank you. As to the pretrial today,
We'd be adjourning for a substance assessment.
Pretrial will be adjourned to September the 4th, 2025 at 9 a.m. Ma'am, you need to figure out how to test timely, okay?
Yes,
I
I will.
don't know if you need to set alarms or what you need to do on if you have one of those smartphones, but get it together. This is only your final warning about that, okay?
Okay, and also about the drug testing. I've never had any issues with drug. Do I still have to do the drug testing?
Your Honor, we would ask the court consider discontinuing the drug testing. There's no drug allegations in this case.
Let me hear from the prosecutor once she gets a chance to review the report. Somebody's having a good
Judge, I've
time.
had an opportunity to review the report, and there is no allegations of drug use in this report. In regards to the late testing, Judge, this is her second OWI. Her first OWI was from August 2024. And in this case, her BAC was 0.289. She was driving down the wrong way of the freeway, almost hit several vehicles. So we do have concerns that the reason why she's testing late has nothing to do with work, but she may possibly be drinking, Judge. Thank you.
And so what is your request today?
I just wanted the court to know the facts of the case, Judge.
Ms. Adams, I think I figured out how they decide who they're violating. Those allegations are extremely serious, and we are just very fortunate and blessed that you didn't hurt someone or yourself. I'm gonna just tell you, this is your one warning, and I said it before, but I seriously mean that. You need to test timely, ma'am.
Okay.
Drug testing is removed, sober link is continued. With this one, I am actually asking them to do an ETG one time per month. I'll see you back here on September the 4th, ma'am, okay?
Thank you.
You're welcome. We'll call the case of the State of Michigan versus Dylan Villeneuve, case number 25S00109.
Tiffany Woods for the people.
Dylan Villeneuve.
Thank you. Who's representing Mr.
Assist-
Villeneuve?
I can step in here. Assistant Public Defender Davi Liba for Mr. Villeneuve. Unfortunately, Your Honor, I see that I don't have notes on this. I believe we had a mishap with our spreadsheet today. If we could pass this matter so I can speak to Ms. Mueller, she can return.
Thank you, I'll pass it. We'll call the case of the State of Michigan versus Larisha Bullock, case number 25S00172.
Tiffany Woods for the
Assistant
people.
Assistant Public Defender Davi Liba on behalf of Ms. Bullock. Ms. Bullock, could you state your name, ma'am?
Larisha Bullock.
Thank you. We're here for a pretrial today.
Yes, Your Honor. Ms. Bullock, have you had a chance to decide on the plea offer we discussed yesterday?
Can I have more time to think about it?
Your Honor, we'd be requesting an adjournment.
That was adjourned to August 14th, 2025 at 9 a.m.
Thank you.
Okay,
Fine.
thank you.
You're welcome. See you then, ma'am.
Okay.
Roll call case of the state of Michigan versus Frank Anderson, case number 23S00230.
Tiffany Woods for the people.
Assistant Public Defender Davia Leva from Mr. Anderson. Mr. Anderson, could you state your name, sir?
Frank Anderson. Good morning, Your Honor.
Good morning, Mr. Anderson. All right, we're here today for a review. And Mr. Anderson has
Yes.
provided his assessment, which I'm very happy to see.
Yes, Your Honor. Mr. Adams also tells me he's completed 1 day of community service and will complete 2 additional days prior to his next court date.
Sounds good. How are you feeling about being at this point then, Mr. Anderson?
What's that?
How are you feeling about how things are going at this point?
Good. I'm not having any problems.
All right, Mr. Anderson, we'll see you back here in 90 days. That's gonna put you on October 23rd at 10 o'clock a.m., okay?
Okay.
Please continue to work on everything that we have discussing and that your probation is requesting. We appreciate you working on it, Mr. Anderson.
Thank you very much, Your Honor.
Take care, sir.
Thanks.
Call the case of the state of Michigan. First, Mark Capaldi, case number 23FB 1508.
Tiffany Woods for the people.
Your Honor, or sorry, Allison Mueller here on behalf of Mark Capaldi. Mr. Capaldi, could you please state your name?
Mark Baldy.
Thank you. We're here for a violation of probation.
Yes, Your Honor, could I briefly approach?
Sure. Right, we've had a breakout room with regards to Mr. Capaldi's case. It's my understanding that you need to have an opportunity to speak to him, Ms. Mueller, about the matters we discussed. Is that correct?
Yes, that's correct, Your Honor, if I may. Thank you.
We put you in a breakout room with him. Who was on the Villanelle matter?
That's me, Your Honor.
I'll pass that one still too. Okay, thank you. Well, we'll call the case of the state of Michigan versus Irvin Patterson, case number 24FB 1130.
Tiffany Woods for the people.
Assistant Public Defender Davia Leva for Mr. Patterson. Mr. Patterson, could you take your name? Could you state your name, sir?
Mr. Patterson, sir.
Hello, Your Honor.
Hello, please state your name for me.
Irvin Patterson. I did one of those scam calls or something. It's coming through right now. Irvin Patterson, Your Honor.
Thank you, sir. All right, we're here for a review. Mr. Patterson seems like he completed the outpatient assessment, but he still needs to do the MAD victim impact panel. And
Your Honor, I believe I sent in documentation for the MAD, but let me double check. Your Honor, can I send that back out again, please?
I'm sorry?
Your Honor, if we could pass the MAD, I can send in documentation of the MAD that Mr. Patterson sent me.
No, I don't want to pass any more cases. You have the proofs?
Yes, Your Honor, he sent me. So previously, he indicated that he couldn't get the certificate from MAD, but he had bank records indicating that he had it. He did send me a bank statement that I actually do have on my desk next to me, which indicates a payment to MAD that's consistent with the victim impact panel.
But he hasn't taken the class yet.
He has, Your Honor, he tells me, but he hasn't, but there was some kind of technical issue where he couldn't get the certificate.
Well, we need to, he's not going to be considered completed until we have the certificate.
Thank you. So, Mr. Patterson, you need to contact MAD to get that certificate or retake the class.
Okay. Like I said, y'all had me bring a statement from the bank where I paid them the $65 and everything, and I took one to the attorney. And while I was in Ann Arbor, I dropped one off at the prosecuting attorney's office too.
Mr. Patterson?
Yes.
Sir, as I just said, you need to have a certificate of completion from the MAD Victim Impact Panel for it to be a completed class.
Yes, ma'am.
Okay. So if you completed the class, call them up and ask them for the certificate. You should do that as soon as possible.
Okay, but I think they want me to pay another $65. I don't know what's going on with that, but I'll do what's need to be done.
Why are they?
I have to pay another $65.
Why did they say you need to do that? Did you ask them why they said you need to do that?
Because they said that something about the money didn't go through, but I went and got my bank statement showing, and I handed it to my attorney's office.
I understand that you've handed something to your public defender, to the prosecutor. I understand that you've done all that. Have you handed it to them to prove that you paid for the class?
Right. But they say they didn't receive the money.
Sir, once again, the question is, have you handed the proofs to them to show that you?
Excuse me.
Mr. Lebo, maybe someone.
Well, I've tried that.
Your Honor, could we approach for a moment?
Sure.
Thank you.
It will pay their money over again.
In the case of all right, we're back on the record in the case of Irvin Patterson. Mr. Patterson, your attorney's going to make some phone calls to see if he can help you to get this issue straightened out. And then you need to try to do the the in-person course. You need to go in person to do it. And we'll see you back here on September 4th, 2025 at 10 a.m., okay?
Okay.
All right. Call your attorney this afternoon or tomorrow so you can keep working through this issue, okay? Okay, sir? I think he's frozen.
Didn't hear a lot of it. It was breaking up.
All right, you need to call your attorney either later today or tomorrow to try to work through this issue, okay?
Yes.
All right, have a good day, sir. I'll
Yes,
see
ma'am. You have a good day.
you.
Bye, Your Honor.
Bye-bye.
Your Honor, was that the 4th or the 24th?
The 4th.
Thank you.
Thank you. The court will call the case of State of Michigan versus Stormy Reed Johnson, case number 25S4554149.
Tiffany Woods for the people.
Your Honor, can you hear me now?
Yes,
Can you hear
sir.
me?
Yes, sir.
Okay. Attorney Bruce Saperstein, P19893, representing Stormy Reed Johnson.
All right, we're here for a formal hearing in this particular matter. Trooper Schreiber is here. Is that the trooper?
Yes, ma'am.
Thank you. Good morning, Trooper Schreiber. How are you?
Good morning. Very good.
All right.
Is there a chance I can meet with the prosecutor?
No, there's a chance you can do that, but you can meet with the trooper to see if you can work something out. We don't stop our docket to have meetings. So if you want to stop.
I haven't been here in a while. I didn't remember that. I'm sorry. I'm only doing this for.
Okay. She's the only prosecutor. We're not gonna stop for you to have negotiations. So
Then let me, all right.
Judge, he can have a breakout room with the trooper. The trooper and I have been emailing, and he does have, has a plea offer in mind, so maybe he can discuss it with defense counsel.
all right, I'll pass this so you can speak with the trooper.
Thank
Thank you,
Ken.
Judge.
The court will recall the case of the State of Michigan versus Dylan Villanove, case number 25S00109.
Tiffany Woods for the people.
Allison Muller here on behalf of Dylan Villanove. Sir, can you go ahead and state your name?
Dylan Villeneuve.
Thank you. All right, we're here on a pretrial and adjourned bond violation. We adjourn the bond violation at your request to today's date.
I'm sorry, Your Honor. I'm just referencing my notes for the bond violation.
He tested positive for THC on April 11th. April
Yes, Your
17th. Missed the sample on April 22nd. Tested positive for THC on April 23rd. Tested positive for cocaine on May 9th.
So
And
the
then-
THC was my first
Mr.
couple
Villeneuve.
ones. Oh, sorry.
I'm sorry, Your Honor. I do see that in my notes. Him and I had discussed the pretrial. I'm sorry, we had not discussed the bond violation. I was going to ask if again I could just briefly approach on this, just explain the status of the case, or it's something I could probably do on the record. I believe that we had adjourned at the last hearing. Given kind of the nature of the damage in this case, I understand that the prosecution does not have to know or indicate what the restitution may be. But given the damage, it would be helpful, I think, to decide the course of settling this matter. But I understand from Ms. Woods that there is no information that can be provided about restitution at this point. Is that correct?
That's correct, Judge. Victim advocate has reached out to the victims in this case, and they are putting together that restitution request, but we don't have the documents from them yet.
All right. Are you requesting an adjournment based on that?
I think we would be, Your Honor. Again, I understand there just may be not verification of restitution, but given the amount that it could be in this matter, it would be helpful to have some indication or like a kind of a range of what we could expect. So yes, would be, I guess, requesting one last adjournment for that reason, hopefully.
I'll adjourn it to August 28th at 9:00 a.m.
August, you said 28th, right, Your Honor?
Correct. And of course, the court is more concerned about the cocaine than we are about the THC, and he's correct. That was at the beginning of the process, so it took it a while to get out of his system. As far as the cocaine go, I am still very concerned about that. I guess on the plus side, since then, we haven't had any more positives. I will adjourn it again if you're asking me to do that to the next court date.
I'm sorry.
To the next court date of August 28th.
Thank you, Your Honor. We appreciate that.
So, I'm sorry. So we're gonna do the violation today still, or no?
The bond violation will be adjourned to the same date, sir.
Okay. Okay.
Don't test positive again, Mr. Villanelle. Whatever you're doing seems to be working, so, all right?
Yeah, I try to keep stay clean. I don't know, to be honest with you, like off the record, like I don't do anything, so it had to have been something.
There's no off the
Sure,
record.
it had to have been something, you know what I mean? Because I wouldn't have
Villanelle?
jeopardized my freedom.
Mr. Villanelle,
Yes, ma'am.
stop. Okay, thank
Yeah,
you.
you're
I'll see you
welcome.
here on August 28th.
Thank you, hon. You have a
Thank
good day.
Mhm. The court will call the case of the state of Michigan versus Mark Capaldi, case number 23 FB 1508.
Tiffany Woods for the people.
Allison Muller here on behalf of Mark Capaldi. Mark, can you go ahead and state your name?
Mark Capaldi.
Thank you. Are we ready to proceed at this time?
We are, Your Honor. Thank you.
Mr. Capaldi, it's my understanding, sir, you're going to admit to violating the terms of your probation in the following ways. Failing to report for over 90 days, being charged with an arson 4th degree, which was reduced to a malicious destruction of property from a report that was MSP report 7727-24. And then also violating the terms of your probation by the new charges out of Bay City related to a date on July 31st. Is that correct?
Yes, ma'am.
Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. So, sir, you're waiving any right to have a hearing and you're admitting that you violated in those particular ways. Is that correct?
Yes, ma'am.
Right. I find that there's a knowing and willing admission to the violation. Are you satisfied, Ms. Woods?
Yes, Judge.
And to Ms. Muller. Sorry.
Thanks, Your Honor. Defense is also satisfied.
Mhm. It's my understanding we're going to proceed to sentencing at this time. Anything else you want to say on behalf of your client?
Your Honor, I understand this has been a long road for Mr. Capaldi. He understands as the choices he's made. He's also, I think, had a lot of consequence. I hope this has been a learning experience, and I know he's looking forward to a fresh start, which I hope he'll use when he gets out of this. We have gone over the recommendation from probation, and I do understand that that is likely the recommendation the court's inclined to follow. And so, and Mr. Capaldi will follow that and engage with the program ordered, and then hopefully will be released to treatment inpatient as soon as possible.
Thank you. Ms. Woods?
Judge, I would leave it up to the court's discretion.
Thank you. Anything you want to say, Mr. Capaldi?
No, it's been a long road. I'll just, before you make your decision, I know you thought that there was times that I was misleading the court. I've been honest with everything about the court, or about what's going on. I would just like to get out as soon as possible. My grandmother is still in the home, and I wait for me to get her out. And I did lose the farm. The probate attorney that I chose, he sold the house, the farm, all the farm equipment, everything. Which is pretty, for no reason. It wasn't necessary, which is pretty upsetting to me and my grandmother. So I would just like to do whatever I need to do to get out of here as soon as possible. hopefully before winter time. So I can get her out of the home and get us situated, and we gotta, find a new place. And yeah, I don't want to take up too much time, but that's just as soon as I could get out, it would be the best. Whatever I have to do for that.
All right, thank you.
And you won't have to see me anymore with him selling the farm and everything. I'm leaving Washtenaw County when I get out of here. We're leaving the state. Once I get out, I'll have my out date up north is September 14th. So by the time I'm done here, I'll be good up in Bay City, and we're gonna go down south.
Thank you, sir.
Yep, thank you.
So I'm going to revoke your probation at this time, sir. It is sentence of this court that you serve 365 days in the Washtenaw County Jail. You are given credit for a total of 175 days. That does include the 12 days that you served while waiting in Bay City. So I did up that to that amount of credit. You are to complete and to serve the balance of that time. But once you complete the CMH in-house program, you can be released to treatment as soon as Bay City allows you to be released. So I'm hopeful that you'll get into that program and get out before your September date so you can go directly into treatment. Okay?
Yep, thank you. How do I contact CMH, or are they going to contact me?
You should contact inmate services and they will help to get you into that particular program. Okay?
Okay, thank you.
All right, thank you. And if any issues arise regarding that, contact your attorney and she will reach out to me, and then I can help facilitate that process or change the request if it can't be met. Okay?
Okay, yep, thank you. Yeah.
You're welcome. Take care, Mr. Quality.
You as well, Miss Washington. Hopefully I don't have to see you again.
Hopefully not. Thank you.
Okay, thank you.
The court will recall the case of Stormy Reed State of Michigan versus Stormy Reed Johnson 25 as 4554149.
Tiffany Woods for the people.
Good morning, Your Honor. Bruce Saperstein representing Stormy Reed Johnson. Had an opportunity. Okay.
Go ahead.
Had an opportunity to speak with the officer and with the trooper, and he was agreeable with a 5 to 10 over a 1-point violation on the freeway.
Mm.
And she's prepared to accept that.
Thank you. Let me write it up. Are we referring to speeding 6 to 10 over? Or is there a different one, which if there is, you'll have to get me the pack code, Miss Woods.
That's a 1-point violation, is that right?
1 second. 6 to 10 is a 1-point violation, correct?
Yes, Judge, it would be 6 to 10. There is no 5 to 10 over.
Okay.
And that pack code for that, Judge, is 257.629C. And that is a 1-point violation.
Thank you.
You're welcome.
All right, ma'am, it's my understanding you're accepting responsibility for an added count 2, speeding 6 to 10 over. That is a 1-point, it is 1 point on your license, and the fine for that is $130. Is that correct?
Yes.
All right. Count 1 is dismissed. Can you pay that today?
I plan on paying it tomorrow.
That's
If
perfect.
I'm not to.
I will
All right.
pay.
Do I come out there to pay it, or do I pay on my?
If you have a credit card, you can go online and pay it.
Okay.
you need to pay it by tomorrow, which is July 25th, okay?
Okay.
That's 135, you said, or 130?
1:30.
130.
Okay. Count one is dismissed, and you're all set. Have a good day.
Have a good day. You have a good day too, Your Honor. Take care.
Thank you,
Okay.
Snyder. Have a good day.
Bye-bye.
Bye-bye. The court will call the case of the state of Michigan versus Ronald Sargent, case number 01-00807.
Any words for the people?
Ronald
How you
Snyder,
doing?
thank you. Please state, I'm sorry, I said the wrong name. Is Ronald Sargent present? Please state your name, sir.
Can you hear me? Yeah, Ronald Sargent Jr.
Thank you. All right, we're here on a application to set aside the convictions, and there are 3 of them.
Oh, okay.
Yes, 1 second.
I should advise you on the bill for this opinion. I assume that the attorney, so the label as project clean slate might be with that.
Okay.
I'm not 100% sure that.
All right.
I would assume that attorneys will know how to label themselves.
Is anyone here from the Michigan Advocacy Program from Legal Services? Ms. Nybert, you're muted. Ms. Nybert, you're muted.
Sorry, thank you, Your Honor. I am here, but I'm not here to represent Mr. Sargent. I think we have Mr. Sargent representing himself.
Okay. Thank you.
I can take a look real quick to make for sure too. Yes, yep, he is here to represent himself.
All right, thank you so much. All right, so you're here on the application to set aside the conviction in this particular case. Can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand, sir. All right, so first of all, have you been convicted of more than 3 felonies?
Well, one in 88, I gotta go to court on the 27th. A B&E and assault to do great bodily harm or something like that. That was back in well, 88. I was 20 years old or something. Yeah, that was over 20 years ago.
That's not the determining factor in terms of the age. I need to know whether you were convicted of more than 3 felonies or not.
Oh, no, ma'am. No, ma'am.
One moment.
Okay.
I just see the one felony conviction that he just mentioned back in 1988.
Yeah, it was 18, D&E or something. I thought it was,
It's B&E.
he was sort of,
It's B&E.
excuse me?
It's B&E.
Okay,
All right. Are there any current criminal charges pending against you, sir?
no, ma'am.
All right. And have you been convicted of any criminal charges in the last 5 years?
No, ma'am.
All right. And why are you seeking to have these charges expunged, sir?
My life is extremely changed. Cause, I got a 20-year-old son, daughter that just turned 18. And ever since they've been born, I was a young man back then now. I think I'm a man. I'm 55 years old. I'm trying to basically, I don't want people to see all my bad stuff I used to do when I was younger. I was young and dumb back then, basically. But now I got a good woman, some kids that changed my life, and I've been with her over 24 years. No trouble. Got my license back 100 years ago. Never had a ticket. I ain't been in trouble. I'm looking to the right instead of to the left and trying to do my best and basically clear up all of my wrongdoing.
Mm-hmm.
I was young and dumb back then, but that doesn't change the fact. But now I'm a man now. You know what I mean?
Are you working or doing anything like that, sir? Are you working?
Yeah, I worked at Wendy's for 18 years, and I quit there probably about 4.5 years ago. And I ran the Roundhouse fitness spot. Now I'm a supervisor at the Shell gas station. I run the nights up there. I've been working ever since for the last 20-some years.
Miss Woods, anything from
And
the
plus, I stopped drinking 3.5 years ago, and I ain't touched a drink since then, and never will again. And that's basically what I've been doing, trying to change my life, and I'm trying to get a food truck within 2 years. That's basically one of the reasons I want to get all my expungements and get my life together, like I've been trying to do. I know it ain't 100%, but I know I'm trying to do my best for my kids and my family. That's basically what I'm trying to do.
Thank you. Miss Woods, anything from you?
No, Judge, I would leave it to the court's discretion. Thank you.
Mr. Sergeant, when you got the driving while license suspended, did you have a commercial license at that time?
I think my license was suspended basically already. I ain't had no license in a while. And I kept getting suspended, driving license suspended.
Sir, have you ever had a commercial license?
Oh yes, I have one.
You did?
Yep, I had a license.
A commercial license.
Now, when you say a commercial, what do you mean?
That you had a CDL or something like that, more than just a standard.
No, I used to have a chauffeur's license back in the day when I was driving a cab, but that was a long time ago.
And how long ago was that?
Probably when I was probably about 19, 20, 21.
Okay, what year are we talking about, sir?
What was that? When did I drive that? Probably 93, 90, I don't know. In the 90s, I know that. And then my license got suspended, and then I didn't have none after that. But I got license now, and I ain't had a ticket or nothing.
When you were driving while license suspended in 2001, was there any injury involved to anybody in that particular situation, sir?
No, ma'am. Mm-hmm. Not that no, ma'am. I'm pretty sure it wasn't.
Right. I also have received letters from people in support of this on your behalf. I have reviewed those. Given your statements on the record here today, I will grant your request to expunge these convictions. I will sign the order indicating the same. Your application is granted. You're all set, sir.
Thank you. I appreciate you. I really
You're welcome.
appreciate you. Thank you.
Have a good day, sir.
Can I ask one more question? Now that I have this other court date for Thursday the 31st. It's called, I guess a clerk hearing. Do I gotta attend that at 8 o'clock in the morning?
What type of court hearing? Where are you talking about, sir? I don't do hearings at 8
Yeah,
o'clock.
because, it's a motion for today, and then it says Thursday, the 7th of July 31st, 8 o'clock a.m. Clerk hearing,
No, that's a
clerk
clerk.
review or whatever.
No, you do not need to attend that, sir.
Okay. And would I get paperwork in the mail, showing that I got granted, or do I got to come up to the court or something?
You can call the clerk and ask them that. I'm not certain how they do it, but call the court, ask the clerk whether they send it off to you or you need to come get it. Okay?
Okay. Thank you. I appreciate it.
You're welcome.
Yeah.
Take care.
Yeah, you too.
Bye-bye. Court will call the case of the state of Michigan versus Angela Zagaman, case number 25S00121.
Tiffany Woods for the people.
Allison Mueller here on behalf of Angela Zagerman. Ma'am, can you go ahead and unmute and
Angela M. Zagerman.
Thank you. We're here for an adjourned pretrial in this matter.
sorry, Your Honor. Yes, Your Honor, that's correct. It looks like we are requesting to ask for an adjournment to either begin or continue the recovery court screening process.
September 4th, 2025 at 9 a.m.
Your Honor?
Yes.
So can I request from you to be transferred to onset, where I do my drug and alcohol test? It's a lot closer to my house.
Any objection? He wants to test it on site as opposed to community corrections.
Judge, as long as it's approved and they send the results to community corrections, I would have no issue with that request.
On site is approved by the court. It's what we use for recovery court anyway, so you might as well get used to that process if she gets into the recovery court program.
Thank you, Your Honor.
You're welcome. Make sure they know that the results need to go over to community corrections. And I'll see you back here on September 4th at 9 o'clock a.m., Ms. Sagerman, okay?
Thank you, Your Honor. Have a nice day.
You too. Your bond is continued with that correction. It can go to on-site. Ms. Johnson, do we need to do anything on our end to make sure that they know that, or?
truth and nothing but the truth, so help you God. Okay. Ink up your right thumb print.
Mr. Holmes? Yes. Who's your attorney?
Me.
Is Brandon.
Good. That's one.
We now call cause number 23 CR 669, the state of Texas versus Riley Lee Holmes. Who is present with his attorney, Brittany
Yes.
Holmes. Y'all aren't related?
No.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sure.
In summary, this indictment alleges that on or about March 17th, 2023 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with in this indictment?
Yes, Your Honor.
Right. It's like there is an agreement that you would be pleading guilty to the lesser included offense of eluding.
It's gonna be the transportation code.
What section is that?
545.421.
Five.
45.421.
Huh.
Mhm.
You sure? Because it's not in this.
Transportation.
In the transportation code, it goes 524.051 to 550. Goes from 524 to
I just
550.
changed it from what I was looking at. 421. Yeah, I'm still going. 47, 420. Gotta keep going because it's right there. Fleeing or attempting to elude a peace officer, 545.421.
Yeah, it's just,
Yes, sir.
it's not in this. It's
Here,
not in the book.
here's the code section, Judge, if you want to look at it.
No, that weren't included. According to section 545.421 of the Texas Transportation Code, a person commits an offense if the person operates a motor vehicle and willfully fails or refuses to bring the vehicle to a stop or flees or attempts to elude a pursuing police vehicle when given a visual or audible signal to bring the vehicle to a stop. Except as provided by subsection D, which is that it would be a Class A misdemeanor if the person is recklessly engaging in conduct that places another in imminent danger of serious bodily injury. It is otherwise a Class B misdemeanor.
Yes, sir.
Right?
Yes, sir. That's correct, Judge.
Which means you face no less than 180 days.
Up to 100.
Up to 180 days in the county jail and or a fine not to exceed $2,000. Do you understand what you are charged with and the punishment range that is? This says a fine not to exceed 4,000. Isn't it 2,000?
It's 2,000, Your Honor.
Yes. Okay.
Are you up for? Judge.
An agreement has been reached where you would be pleading guilty, sentenced to 30 days county jail. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes.
You know, this pad is odd.
I know, but this other one's acting out, Judge.
Okay.
October 1st, we're supposed to be able to order our new tablets. New budget year. But hang on till then.
So again, how do you plead to this, guilty or not guilty?
Guilty.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. And you need to sign at the bottom.
Oh, yes.
I hope it'll work. That stylus is not friendly with the pad.
That's your signatures. There, in there.
Did you sign that document?
Yes.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into
No
evidence
objection.
without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes, is a pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement. I have nothing further and find you are pleading guilty to this lesser included Class B misdemeanor of eluding law enforcement voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this Class B misdemeanor. And following this agreement, you have heard my sentence to confinement to the county jail for 30 days. You will be given credit, of course, for time you have served. You understand what has happened today?
Yes, sir.
Have you served more than 30 days?
No.
Yeah. No.
He only has 5 days.
Okay, well, he's got to be ordered to report.
Yes, sir. He's going to go to
When?
custody.
Immediately? When well, we got to figure that out.
Mm-hmm.
You gonna go into?
Get it done.
Today my son's birthday, but
Can you go tomorrow, Friday,
yeah.
at 6 o'clock? Can he report Friday?
Yes.
At 6 o'clock?
But you need to hang around till they take that monitor.
That's fine.
Also, don't fail to do that. They're going to be expecting. If you fail, then you get into all kinds of more trouble.
I'll be there.
And then I can undo this deal. And then you're starting from scratch, because she's fashioned a pretty good deal for you.
Thank you.
Yes, sir.
Thank you.
Okay.
There's someone here to take the monitor from you.
Okay. Thank you.
Okay, wait.
And then I do.
No, you can come on back here. They're here. Thank you. So. Hold on.
Stephen Allen. Here's this. Thank you.
Yeah. You want to do
We're all for straight probation. With restitution.
22-40573 is now called the State of Texas versus Stephen Dustin Allen, which is you. Present with Mr. Kimber, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
So waiving your name.
In summary, this indictment alleges that on or about June 29th, 2022 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of metal or body armor by being a convicted felon. As of 2006, you convicted in this court of the felony of fraud. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this third degree felony? Guilty or not guilty? Are you? Both?
The timing was funny.
I understand, but I thought it was ironic both you and your attorney pleaded guilty.
I can possess one.
Which is
If he wants to take case, no.
something that's overdue, long overdue for him.
I can legally possess one.
Are you pleading guilty, Mr. Allen, voluntarily and because you are guilty?
Yes, sir.
Oh, I'm going to show you, sir, what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Sir.
State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You felt it. You are guilty of the crime charged in any lesser included offenses. You giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the presentation provided by your lawyer. Thank you so much. All of this is true of state, so help you God.
Sir.
State's Exhibit 1 is part of the record without objection and admitted. Anything further? I'm going to follow this agreement if nothing further and find you have pleaded guilty, Mr. Allen, voluntarily. You're not only competent to do so, you understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of body armor. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement is suspended. You were placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, there's a fine of $500 attached to this. Please do well. We can get it shortened in a third. Okay. Anything else? That is all. Thank you. Please see the probation officer.
That'd be the I-1 Curtis class. You know, they got a body on.
You know, the thing is, hey, that statute is people have to be, they think, oh, that's body armor. Well, it's got to look a certain way. No, it's just a piece of metal that could arguably say, oh, that's capable of stopping a bullet. And you're wearing it.
It has to be.
Yeah, but you got to wear it. No, it's not a barrel. You have to wear it.
There has to be some aspect. Absolutely.
I think if you put in a string around your neck and hang it around your chest, I think they got you.
Like Clint Eastwood.
Yeah.
They got hundreds of parts.
Good, bad, and the other.
Is that that?
I know the movie. I've never seen it.
All right, I was giving a. You want to know what the credit?
Okay, David, there's a lady here. Is this yours?
She's mine.
Right,
Judge.
right, what are you gonna do with this lady? Don't let her just sit there, right?
Let me get off here. Honor.
Yeah.
Okay, come.
It's like, yes, I'm just gonna look for that guy. Yeah. Does it have on here? Or is that mine?
What's this?
This is. Maybe tomorrow. Okay, gotcha. So, just because I'm probably not gonna be here. Yes, ma'am. So, that's weird. Yeah. So, yeah, didn't want to. Does he have his? Like, they'll do it. They do. Okay. Yeah, and I know the jail already, but okay, you know, there's different shifts. Yes. Yeah. Okay. Yeah, just tell them to make sure to bring that. Okay. Well, I have to go with what I have, and you know that I do. So.
Sarah.
I mean, I would only do all three of them. Yes, Your Honor.
Mr. Kimmler, what she's trying to say is she dances with who bring her. It's whatever's in that file.
Oh, the other one was fraudulent use of credit debit card.
Let's pick up the matter of this contempt. Where's your, where did Alan go? He just walked off? Did y'all talk to him?
Yes.
What are y'all gonna do? Go without him?
Yes.
All right, come on up.
I'm the credit card.
And I've also,
She made one.
where's Mr. Angel? All right, we need him to. Here, can you make some copies of this, please?
You have to have more than 5.
Actually, the damages were far less than I thought they were gonna be. 8,000. I thought it was gonna be 2 or 3,000.
Combination.
But still, you don't want to pay a dime. Somebody wants to pay any money for, you know. It is up to being 500 and something divided 3 ways. That's the way you're gonna do it. Come on up. Just go on up, sir.
That would be like the presumption, you get a jury.
All right, we call, you're staring out and jail. You have to speak up, sir.
Yes.
Thank you. And Charles Nicholas Senior.
Yes.
And Charles Nicholas Jr.
Yes, sir.
Oh. On July 18th, which is 6 days ago, last Friday, this court was in court session on the case of Stephen Angel as a defendant in a murder case. And the jury had returned a verdict finding the defendant guilty of murder. It was about lunchtime. We broke for lunch and I ordered the jury to return back and the parties to return back after lunch to begin the punishment phase of the trial. While we were in that phase, Mr. Grove and the parties were exiting the courtroom. Mr. Grove, David Grove, one of our public defenders, was proceeding immediately into a hearing that we were conducting on a plea. And what was the case, David? Do you remember the defendant's name?
No, sir.
Okay, because you do a lot of them. Thank you. Here. Everybody gets one of these. You got one of these. Here, give this to Mr. Andrew. Thank you. And as the parties were exiting, Mr. Grove was beginning to get this plea underway, and then we were breaking for lunch and we were going to return back. The jury was just exiting here at the doorway. The court heard voices, loud voices. There was a slamming and bumping up against the door. The bailiffs rushed out to take care of what was obviously a disturbance going on at the courthouse door. And the court had to terminate in the middle of the hearing and postpone that for a later time as we were resolving what the disturbance was. So the court walked out and then saw the 3 individuals being arrested. And these were family members of the Stephen Angel case matter, people who were involved, victim, defendant, related, 3 people related to the parties. The court, in just a matter of minutes, actually received a copy of the video of the proceeding. There's a camera right over our doorway. And I looked at that and it was plain to see what had happened, where three people, the parties involved in this matter had gotten into a confrontation, and shoving and the throwing of fists were part of a fight that was going on. Involved was Charles David Nicholas Sr., Charles David Nicholas Jr., and Starren Angel. Unfortunately, these are Mr. Angel is related to the defendant, and then the Nicholases are related to the deceased in the murder case involving Stephen Angel that the court was in the middle of and had just received a verdict. So the court brought the individuals in because the court was in a multitude of important matters at the time. We could not fully conduct a hearing on that matter, but the court reviewed and is following the Court of Criminal Appeals decision in 1987, Ex parte Daniels of the Texas Court of Criminal Appeals, which is quite similar in issues and facts to the issues in this matter of contempt, as the court ordered them to be presented to immediately come before the court, and the court orally charged them, the three individuals, with contempt. And the issue became, is it direct contempt or constructive contempt? That is, direct contempt or indirect contempt. Direct contempt occurs when it occurs in the presence of the court. Indirect is a matter that occurs outside the presence of the court, but in each case, disruptive behavior, committing a crime, failing to follow a court order, all of those are part of the equation that the court has at its disposal in dealing with matters to ensure that the court's business is conducted in a civilized, peaceful, lawful fashion. The big question, the big issue here on this case is direct contempt versus indirect contempt. Direct contempt involves behavior which occurs in the presence of the court. The court was sitting where it is now, on this bench, in this chair, and the people in the court had been recessed on the murder case on Mr. Angel for lunch, and we were return afterwards to pick up the punishment phase. And at the doorway, the court, as people were leaving, the court then was, as Mr. Grove was beginning his plea with his client, the court heard loud noises, shouting, banging on the door. The bailiffs in my court exited quickly and moved toward the noise and exited. And this hearing had to be stopped. So it interrupted the court's hearing that was being held with Mr. Grove and his client. But yet the court went outside and saw these three individuals being detained by law enforcement. The court saw some jurors watching from a vantage point not far. I noticed some of the jurors were watching and from that murder case, and then they left. There was damage to the chairs outside the courtroom. And then the court brought the three individuals here today, Mr. Nicholas, and Mr. Angel, and then spoke to them about their actions, which this court deemed to be disruptive and in contempt. The court had also, within just a few minutes, 5-10 minutes of the event, received a copy of the camera recording of the scuffle, and this court picks up from when the parties were leaving this courtroom at the doorway, and then this court saw, even though there's no audio to it, the court saw the confrontation begin, then turned shoving and punch throwing. And then authorities intervened quickly. But at the conclusion of all of this, what had happened is this court's business was disrupted. The scuffle is occurring at the doorway of the courtroom. Jurors of this case were in the vicinity and could see what was going on. This is bad in many different ways. And this isn't the way the rules of procedure and the rules of handling matters in this courthouse are supposed to be handled. So, to preserve the Court of Criminal Appeals, the highest court in criminal cases for Texas, has stated that to preserve order in a courtroom for the proper conduct of business, the court must act instantly to suppress disturbances or violence or physical obstructions or disrespect to the court when occurring in open court. And there is no need of evidence or assistance of counsel before this court can exercise its enforcement and punish those who are disruptive. And this is all concerning the dignity of the court and the authority that is necessary for us to resolve issues in a nonviolent, higher educational level method that the justice system is supposed to be a part of. Now, the question becomes whether this occurred in the presence of the court. And this court decision, Ex parte Daniels, 722 Southwest 2nd, 707, which is a 1987 case, a decision by the Court of Criminal Appeals in Bonk, that is the whole court made this decision because they felt it was important that all the judges be heard in the matter. And the issue became, did it happen in the presence of the court? If it's in the presence of the court, I can deal with it immediately, or I can postpone it like I've done and deal with it later. But in that special scenario, that's called a direct contempt proceeding, which the parties do not need a lawyer, aren't required to have a lawyer. This court can deal with it as soon as it's expedient. If it's not in the presence of the court, then it becomes what's called civil contempt, which still can be punitive, but in civil contempt, the parties are allowed an opportunity to hire a lawyer and can deal with it at a subsequent time. However, this was a case that occurred dramatically similar to the situation here. The question becomes, what does in the presence of the court means? And the Court of Criminal Appeals ruled this way. The presence of the court does not necessarily mean in the immediate presence of the trial judge. The judge has, the court has held that the court is present and things happen in the presence of the court whenever any of its constituent parts, the courtroom, the jury room, or the doorway, are involved in, or all involved in the work of the court. And it is for this determination and reason that the courts have held that you can be committed to direct contempt proceedings when someone is just placing publications, contemptuous publications, in the corridors of the courthouse where prospective jurors would necessarily see them. I mean, that's the far range aspect of how this court can have authority. We're not talking about people setting publications in the corridors of the courthouse that might affect jurors. What we had here was a fight going on at the doorway of this courtroom after the court had just immediately received a verdict finding the defendant guilty. And people related to the defendant and the victim were scuffling, and in the midst of an assault, it also interrupted the proceedings that the court was holding with Mr. Grove and his client, which had to be postponed and still, and then were disposed of at a later time. And then the court also lost its bailiffs that are required to be present at all times in this courtroom during its business, as they went out to immediately stop the scuffle and deal with the problem that it was having to deal with. So what this means altogether is this works just as though y'all had fought in front of it. Because we had that murder case, and then we went into another murder case and just completed that second murder case last night. I've asked the parties to come before the court. The court, because it was having to deal with those more important matters at the time, did bring the parties present, then postponed further proceedings. But it's the court's finding that these are direct contempt proceedings, and this court can make its decision. Did anybody stay in jail overnight? Mr. Angel, how long were you in jail? Before you posted a bond?
Yeah, about 2:00.
A few hours?
Overnight, and the next.
It was overnight? Okay. What about y'all?
We stayed about 7.
Sir?
About 7 o'clock that night.
That night, okay. But y'all were arrested, brought to jail, and then.
Yes.
The damage done by this ridiculous behavior is ended up costing $519.26 to the people of the taxpayers of Jefferson County. So each of you are going to pay your part. That's $175 each. Everybody, you, Mr. Angel, and Mr. Nicholas and Mr. Nicholas, you will be ordered to pay restitution to Jefferson County. The taxpayers, Jefferson County, the county treasurer had to buy the new equipment that is now placed out there, you will be ordered to pay that. Do you understand, everybody?
Yes, sir.
When can y'all pay that?
I pay today.
How about you, Mr. Angel? How much time do you need?
Feel the taxpayers, if you want to implicate them.
No, I'm not implicating
Taxpayers-
them. They're getting paid back for the
All right,
loss.
and listen, the taxpayers' time is not only cash, money is not only cash, but time is money. And money is time. So I feel they can get that back from me through time.
You're still going to pay the restitution. Do you understand?
I will.
Okay. Each of you will be ordered to serve 3 days in jail. 3 days in jail. Does everybody understand?
Yes.
Everybody understand? It's and ordered to pay restitution in the amount of $175. You'll be given. You've already served 1 day. I give credit for 1 day for each of you. So, when can y'all begin the service?
Can I start it? Can I turn myself in tomorrow?
Sir?
Can I turn myself in tomorrow?
Yes, sir.
I just started school this week and I want.
Yes, sir. That's just 2 more days.
Okay.
2 more days. When can you go, Mr. Angel?
Today.
All right. And
I need to call my job and everything.
yes, sir. Okay. All right. Do that and let me know, and then we'll work with y'all. Also, a part of the judgment, again, each person pays $175. That was put into the equation, so the court decided you didn't need to do 6 months. But the taxpayers, we all, including you, all of us are taxpayers one way or the other in this county. But we all pay our part. When tax revenue, assets are damaged, person responsible for it, the people responsible need to pay back for the people. So the court will order each of you to pay $175. And if everybody's credited for 1 day, 2 more days at on a time that y'all can work with. And we need to know, again, Mr. Nicholas, on you, you're going to, Mr. Angel says he's going to turn himself in on or before 6 o'clock today.
No, I'm just taking from here.
Well, do you want to turn, you're going to get credit for the day, but you can stay out until 6.
All right, we can do that.
Okay. But on or before 6 o'clock. Yeah, your word's good enough. And what about Mr. Nicholas and Mr. Nicholas?
Tomorrow.
Okay, tomorrow?
Yes, sir.
All right. And
6 o'clock.
then that just gives you 2 more days. But please, and also, when are y'all going to pay this restitution back? You said today?
I can pay it right now.
Okay. Well, I'm not sure how that.
Judge, I'm not quite sure.
I think that-
We collect the money. I'm gonna have to make some phone calls.
I think the jail normally does that. Don't the jail collect on restitution when they're?
No, I don't think so.
No, the jail doesn't collect any money, and I can't take in any money on behalf of the court. I'm gonna have to make some phone calls. If everyone can just hang tight, let me figure out how we can get the money from.
Yeah, let's figure that out because this is kind of unusual. And so we can get it done right. Okay.
So if everyone can just hang tight for about an hour, let me try to figure out how to get that and get the paperwork done for them.
Okay.
And-
You can work on that right now.
Yeah,
Thanks.
yeah,
Just
no.
hang loose, not an hour, just about 20 minutes. We ought to have an answer. Okay. All right. Yes, sir.
I want to apologize to you.
That's all right. That's all right. It's tough for everybody. It's tough for everybody. But every case we have, I've had 600 jury trials here. 600 I've presided over. It's hard on everybody. But the worst thing you have is to show violence here in the courthouse when we're trying to resolve problems in a modern, sophisticated way. Now, people aren't always happy with the way things happen, but it's under rules, the rules of evidence. I helped write the rules of evidence, the code of criminal procedure. There's rules. We're not cavemen that go out there and just seek our own way of justice. I mean, it's under rules, or it would be chaos. And we've developed it because that's why we're the leading country on the planet. People want to be like us in the way we resolve problems. But this building is filled with problems that we're having to resolve. And a lot of it is very emotional. And then nobody can appreciate it more. Everybody needs to know. I was in the United States Attorney's Office. I was the United States Attorney for 20 years before this. And then here going on 20 years. And James Byrd trial, I'm right in the middle of that, prosecuting that. You want to talk about emotion. Emotion, nothing was more, has impacted my life and this country than what happened in the James Byrd matter. But how did we dispose of it? How did we resolve it? We didn't just go out and just start fighting and disrupting and seeking immediate justice. We did it in an orderly fashion. And at the end of the day, people were executed under rules of order. Mr. Byrd didn't get that. I mean, he was brutally murdered for no reason except for his race. And that's one of the rules. We're all in this together, all of us. We all look different, unique. We're all unique people, all of us. But we're also fellow Americans and citizens that have to live together, not only on this planet, but in this country, and deal with our problems. All of us have problems, every one of us. There was no perfection in it, but we've got the thing we have that's important is we have each other that we try to get along with. And because we're stronger when we work as a team, as a unit, all shapes, sizes, and colors. And these are emotional things that occur. But when we lose our focus and then resort to violence, then the rules aren't applicable anymore. And people get hurt, and it's a bad example. And it's certainly not anything that we want this courthouse and our county to be known for. It's known for justice. That's the kind of thing that it was meant to be. Just when something bad like that happens with James Byrd, you don't just take it into your own hands. You work it deliberately under the rules and make sure that justice is served. That's what the Attorney General ordered me to do, is see that justice is done and make sure that those people are held accountable and fairness, but justice is served. Yes, I think I saluted that lady because she was that kind of lady. She was a general. But it works. I've seen it work. I know how it works. And when something like this happens, that's just a bad example to set. But yeah, I've been upset. Everybody loses composure. You have lost composure. Okay. We're fixing this. We move on. We do better, get this behind us, and be the best we can be. Anything else? Awesome. All right, let's live together, try to live together and work through this, because we've got winners and losers and victims all the way around here. And we'll put everything back together and move forward as best we can, peaceably. Right? Yeah, everybody. That's what's right. And here we got families. Y'all know each other. And like I said, my grandmother, my grandparents, my dad grew up about a block or two from where this happened. And so I was over there all the time. I played in Gillum Circle all growing up as a little big kid. And it's not supposed to be a place where there's 88 people shoot 88 times in the residence area, in a neighborhood. It's supposed to stand for something better than that. People go to live together peaceably as best we can with all our differences. Still, we're fellow human beings and fellow citizens. All right. Anything else? That is all. When we're in recess. Thank you.
Yeah.
And the court has the zip drive of the video of the scuffle that occurred outside the courtroom door on 18 on last Friday, July 18th, and this will be marked as Court's Exhibit 1 for the purposes of this record in this matter of contempt. And again, just to complete the record, that this matter was postponed for 6 days because of the issues concerning 2 murder trials going on at the same time that we were conducting. And the court was unable to complete, to have a thorough hearing that it held here today, but treats it as direct contempt and also uses the cites Ex parte Daniels 722 Southwest 2nd 707 1987 Court of Criminal Appeals decision on handling the matter as a direct contempt, as the court finds that this this occurred in the presence of the court, even though it may not have been in the immediate presence of the trial judge. This court still was interrupted in its proceedings. The scuffle happened at the courthouse door, courtroom door, the banging on the door. The bailiffs exited immediately. I had no bailiffs to complete the next hearing that was being held. And then the court decided that, based upon the Ex parte Daniels decision, allowed the court to consider this as direct contempt. The hearing was postponed until today, after yesterday's decision, last night's decision in the second murder case that the court was handling had been completed. And so then the court moved forward with the direct contempt proceeding this today and made its decision. All right, we're in recess. Yeah, Court's Exhibit number 1 is part of the record in this matter. Yeah, we don't have really a docket number, do we? It's, I'm just gonna mark 13th.
She got reset.
It's gonna be reset for another hearing.
It's for another now.
He can go back and he's fixing to get out on bond. That's we can cut the wire off of it so she can get out. Okay, thank you.
Thank you. Here is also, here is, courts. I'm gonna add on the record. That was Courts Exhibit 1. Courts Exhibit 2
What's the
is
definition?
the restitution for the broken chairs outside that occurred from the scuffle that was made a part of this contempt hearing. And this is Courts Exhibit number 2 on this date, and it's made a part of the record. Court ordered each party to pay a portion, $175 each, toward this restitution. And Court Exhibit number 2 is the restitution determination from Hernandez Office Solutions that replaced the chairs that the Jefferson County had to pay for. And this is the payments to the auditor's office is where y'all really need to make the payments. Auditor's office. Yes, sir.
Going to set up the movie question you said. And you can get about the old part of this.
I don't know, but we got it. Or we got a bit an invoice.
I just walked out of warrant at 3 payments.
So if it was anything about me.
All right, anything else?
I will send them an email, but she also needs to sign a release that on site so that they can send it to community corrections.
All right, thank you.
You're welcome, Your Honor.
The court will call the case of the state of Michigan. You're all set, Ms. Ackerman. Have a good day.
I will. You do the same. You have a nice day.
Thank you.
You're welcome.
The court will call the case of the state of Michigan versus Robert Wilson, case number 13S00174.
Tiffany Woods for the people.
For the record, Your Honor, Kelly Collins, P73222 from Project Clean Slate, on behalf of the defendant, Robert Wilson, who's present on Zoom. Mr. Wilson, would you please state your full legal name for the record?
Robert LeVar Wilson.
Thank you. Good morning, Mr. Wilson. We're here today I'm good. We're here today for an application to set aside the conviction in this particular case.
That's correct, Your Honor. This is my client's application to set aside a 2013 conviction for driving while license suspended.
Thank you. Sir, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right. May you establish the factual basis through your client, please?
Will do, Your Honor. Mr. Wilson, as I stated, we're asking the court to set aside a traffic offense for driving while license suspended. Will you please confirm, have you been convicted of more than 3 felonies in the state of Michigan?
No,
Was that a no?
no, I haven't.
You have not. Okay. Do you have any pending criminal charges?
No, I don't.
Have you had any criminal convictions in the past 3 years?
No,
And this is a traffic case. Was there any injury that was involved for this offense?
no,
Was there any death that was involved for this offense?
no,
Were you operating the vehicle in a commercial manner?
no,
Did you have a commercial driver's license at the time of this offense?
no,
And since this offense, do you have a valid driver's license?
yes,
What was the reason you didn't have a driver's license back then?
driver responsibility fees.
Okay, and when they did away with the driver responsibility fees, you were able to get your driver's license?
Yes.
How long have you had your driver's license for?
Several years now, well, little around COVID.
Okay, and are you working?
Yes.
Where do you work?
Stellantis, formerly known as FCA Chrysler.
And what do you do there?
I am a production worker.
Okay, and can you tell the court why you're seeking the expungement?
So I can make more money and better my career off, because it's a job there that I want and it requires driving, and I can't get it because of this on my record.
Because it's on your criminal record?
Yes.
Okay, so this having the expungement would help with your employment opportunities?
Yes.
Do you have any goals to change into the healthcare industry?
Yes, I do as well.
Can you tell us about that?
Yeah, I'm trying to become a nurse.
Okay, and
And it's
what has been
stopping
the
me.
barrier?
My record, I can't do nothing with anything on my record. They won't even allow me to go to school or attempt anything unless I have something saying that it's going to be a sponge or anything like it's coming off.
Is there anything else you want the court to know about why you want the expungement?
To better my life, off career, my family, and everything else. Besides that, like, it's been a barrier on me, even though like I feel like I'm free, but with my record, it's feel like I'm secondhand free. So it's like I'm free, but I'm really not, because I was running into issues with applications that I had to answer yes on that I'd be ashamed of. And I'm just ready for that to be past my life.
Okay, I have no further questions, Your Honor.
You. Anything from the people on this?
No, Judge, I leave it to the court's discretion.
No, thank you. Great. Thank you for doing such a thorough job with that. One moment, I gotta find the Attorney General response. So the Attorney General did respond on June 4th, 2025, indicating that if the court held a hearing in this matter and found that he met the statutory eligibility requirements, they had no objection and thought he would be eligible. I do find that his post-conviction circumstances are consistent with the court's desire to find that he has changed and it warrants setting aside. And I also find that your desire to move forward and your attitude is refreshing, Mr. Wilson. I'm glad to see that you want to have better for yourself and for your family. You seem to have some very, I guess I should say, reasonable but yet positive goals set ahead. And I hope that you meet each and every one of them. Congratulations. It is my honor to sign once it comes over.
Thank you so much.
Setting aside your conviction, sir. And I wish you nothing but the best in life. Take care of yourself.
You too. Thank you.
Thank you.
Thank you, Your Honor. We'll
Bye.
submit in order.
Thank you.
Mr. Wilson, you're all set for today.
Okay.
The court will call the matters of Kylene Myers, case numbers 24S447059, B and R.
Tiffany Woods for the people.
Why not? Definitely like into the.
Kylene Myers, please unmute and state your name.
Hello.
Please state your name.
Tyler Myers.
Thank you. Mr. Myers, on July 10th of 2025, I found you in contempt of court and indicated that you needed to pay on your fines and costs in order to purge your contempt or 10 days in jail. Well, did you make any payments?
I was planning on making a payment right now. I'm making payments. I'm making that payment today. I gotta talk to my mom, but I'm going to make that payment. My mom is for sure. She's gonna. I got help.
Sir, we're beyond going to make payments. Last time I ordered you to do jail time or you could pay it and purge it. You didn't do either. Bench warrant to issue. You can do your jail time.
Hello. Pretty good.
No bond. I'm issuing a bench warrant for your arrest. Roll call the case of Justin Ridgway, 24S44359, A, B, and C.
Tiffany Woods for the people.
Okay. Give me a moment. Sure, someone will figure it out.
Hello. Hello.
Hello, sir. Please state your name while we wait for someone from the public defender's office to come in.
Justin Robert Ridgway.
Thank you.
Assistant Public Defender Don Filipo for Mr. Ridgway.
Thank you.
Mr. Ridgway, are you able to turn on your video by any chance?
Yeah, I think. Oh, there it goes.
We're here for 2 pre-trials and a show cause today.
Yes, sir. With regard to the pre-trial, they're requesting an adjournment. With regard to the show cause, I believe that would be for payments.
Yes, it is for payment.
Thank you. That was not on my docket, I believe, probably because of the civil infraction. Mr. Ridgway, would be able to set up a payment plan on those?
Me?
Yes,
Yeah.
your name is Ridgway.
Yes.
You owe $180 on your ticket, sir. How
Yeah, I
much
can
can
pay it
you
right
pay?
now. I'll pay it right now.
I'm sorry?
I'll pay it right now.
Oh, you're gonna pay it right now, okay.
Yeah.
And Mr. Ridgway, when you spoke to Mr. Mansur, did he discuss what's suspending your license?
Last time it was driver responsibility fees, and then when they took that off, they did it for some other reason, and then they found out that was against the.
Let me rephrase that. Do you know why your license is suspended?
Yeah, it's just driver responsibility fees. Basically, now I just have to go down and get it back. I think.
Okay.
If I
Okay.
read that paper right.
Okay, great.
Okay, how long of an adjournment are you requesting?
Mr. Ridgway, about how long do you think you need to get your license back and your plates taken care of? Well, it looks like you already got the plate, so let's need to adjourn for the license.
3 weeks.
Your Honor, would that be available?
Yeah, you can get longer than that because I don't have a 3 week date at this time, September 4th.
Thank you.
Thank you, Your Honor.
You're gonna pay the ticket today?
Yes.
Okay. I'm indicating here, you say you're gonna pay today, and if you come back and you haven't paid, then you have to show cause as to why you shouldn't do jail time for failing to pay your ticket. Okay?
Yes, ma'am.
I'll see you back here on September 4th, 2025 at 9:00 a.m.
All right.
And Mr. Ridgway, if you have trouble restoring your license and you don't know what's going on, please give the public defender's office a call so I can help you with that, okay?
I will. Thank you.
We'll call the matters of Mr. Micah Jones, case numbers. I guess it's one case number 20 FB 1672.
Assistant Public Defender
Three people.
Assistant Public Defender Davi Leba for Mr. Jones. Mr. Jones, can you state your name, sir?
Micah Jones.
Thank you. Mr. Jones on his newest violation. This is the 5th violation for Mr. Jones. It alleges that the defendant committed a criminal offense on July 9th, 2025 for retail fraud, theft, second degree. Police report number 25003557-001. You're entitled to have a hearing on this matter, at which time if it is found that you in fact violate the terms of your probation could be revoked, and I can tell everybody that I intend to revoke it, and he can just finish the jail time.
Yes, sir. I would be asking to adjourn the violation. This appears to be a new case that may or may not be charged.
Mhm.
Sure. Mr. Jones would also like me to ask the court if the court would consider release to treatment.
Response from the prosecutor.
Judge, in regards to the adjournment and the request for release to treatment, I would leave into the court's discretion.
Mr. Jones obviously needs treatment. I mean,
Yeah.
that's what his problem is.
Yeah.
I've talked to him about it before. We've had many
And
discussions about.
I remember our conversation like months ago, and I should have had took it, and I should have had did what you said. Like you said, maybe you're having a down spiral, and it was just my mental health, and it's just been a lot, Judge. Like my new place with Avalon, I love it, but they're moving me to trying to move me to Miller Manor because like me being from here, it's a lot. Like the place where they placed me is just like not right for me and my mental health and with my sobriety. So it's just like, yeah, I just need some help, really.
The VLP in this case is adjourned. For the status of the new charge. Do we know if it's even, so you're saying it hasn't been authorized yet? Ms. Woods, are you able to see an on base whether you have the new charge pending?
I'm checking right now, Judge.
Thank you.
And just to be clear, I don't have any documentation regarding the new charge other than the number on the probation violation report.
I understand.
I know that a retail fraud of the third degree was charged. That was charged on 7/8 of 2025. And then he has another case that's pending charging. And that's still pending review.
And does he need to be arraigned on the one from July 8th, or has it been submitted to the court? Like, do you know where we are with it?
Let me check, Judge.
All right.
I don't believe he's been arraigned on that, Judge, because I'm not seeing any arraignment notes in the file.
And I
Are
see
you
no
able to-
indication of that on my end, Your Honor.
And it doesn't show up anywhere in JIS yet. I'm trying to figure out whether it's been submitted to the courts yet so he can get arraigned.
We're pulling up right now.
Okay.
Your Honor, I don't see any cases in JIS that are new misdemeanors with a 25 case number. I do see one, which I believe would be the first one that was referred to. And that one, I see that he was arraigned on April 16th at the 14A1 District Court, but not the second one.
I don't think a July 8th could have been arraigned on April 16th.
I would agree.
Okay. All right, so Ms. Woods, I don't know if there's anything you can do to expedite those two new charges so that he's not just sitting there and can be released into treatment with a GPS tether. Defendant is remanded with release to treatment. GPS tether. I was trying to ask these questions so I can set a new court date because I also don't want him to just keep coming back and nothing is moving forward.
No, on the 6th, they said it was a hearing. The hearing of one of
Mr.
the
Jones, that's on the prior retail fraud, the April 16th one.
Okay.
On the 6th of August.
Yes, Your Honor.
All right. I'm going to set this for August 28th, and hopefully some of those other charges will have caught up by then. Mr. Lebo, you may want to continue to reach out to the prosecutor's office to see about moving along those new charges or denying them or whatever they're going to do so that your client's not just sitting there. But like I said, I'm allowing him to be released to a treatment program.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome, sir. You're all set, Mr. Jones.
Thank you.
Try and best you can in your environment. Thank you.
All right, thank you.
You're welcome. All right. I guess we need to do failure to appear.
No. Yeah, I'm not gonna let anyone know.
Okay.
I'm also gonna let him Thomas file and then.
Let's do them one at a time because they get confused.
G is coming in first, Your Honor.
All right. Thank you. There's a device labeled Moto G 2025 that was just allowed into the virtual courtroom. Could you please unmute and tell us your first and last name?
William Squires.
Thank you, Mr. William Squires. We'll get your case pulled and get you ready to be called.
Did you guys get my gun safety certificate?
Yes, we did. You're gonna go into a breakout room with Mr. Lebo when what happens?
When Ms. Muller returns from her break.
As soon as Ms. Muller returns, you'll go in with your attorney. Okay, Mr. Squires, please mute your device.
Mute it?
Mute it, correct. I have not called your case.
Okay. Hang on.
Thank you. We'll mute it for you. Thank you. All right, next one in. Okay. There's a device labeled iPhone that was just allowed into the virtual courtroom with the iPhone. Please unmute and tell us your first and last name.
Am I on mute? Good afternoon, Your Honor.
I'm sorry, what's your name? Good afternoon.
Amadou. I was trying to make sure it was on mute, like I'm here with. I'm gonna find a seating place. I did not, I was waiting on the line while I was at work. I just walk up
Sir,
to
who are you talking to in the middle of court? Please mute your device.
Okay, I'm all set. Sorry.
No, I haven't called your case, sir. I just want to know who you were. Since
Oh,
you came
okay.
in labeled phone only, please
Okay.
remute. Okay. Okay. There's a device labeled Thomas Carl, Karl, that was just allowed into the virtual courtroom. Could you please unmute and first of all, tell us whether that is really your first and last name? And if not, what your first and last name is?
My first and last name is Thomas Carl. I'm just logged on to try and watch my son Cole Leonard's courtroom proceedings.
All right. You need to do that from YouTube, sir.
Oh, I was not aware of that. Okay. Thank you.
Thank you. Thanks. Mr. Lebo, are you able to handle the Williams matter? Was someone able to meet with him and go with the PSI?
Yes, Your Honor, and that was me.
All right, thank you.
And it's the court receipt of the, my apologies.
Go ahead.
It's the court receipt of the letters from Mr. Williams' family.
I am definitely in receipt of them.
Thank you.
You're welcome. The court will call the cases of the state of Michigan versus Devin Williams, case number 23S00063, and it's just the one case actually.
Tiffany Woods for the people.
Assistant Public Defender Daffy Lebo for Mr. Williams.
Please get them to unmute you, Mr. Williams. Please state your name, sir.
Devin Williams.
Thank you.
Yes, ma'am.
We're here for sentencing today.
Mr. I have reviewed the recommendation with Mr. Williams. We would ask the court to accept the recommendation. I would like to allocate on Mr. Williams' behalf, and I believe Mr. Williams would like to speak to the court as well.
Thank you. Ms. Works?
Judge, I've also had an opportunity to review the report and I'd ask the court to follow the recommendation. Thank you.
Thank you. Allocution?
Yes, sir. So Mr. Williams is eager to show the court that he can comply with conditions and remain sober. When he absconded previously, he tells me that he had recently moved 3 times. He was caring for a child. He'd started a new job. He was in an extremely chaotic phase of his life. He understands, and I understand, that's not a good excuse, but it is the explanation of why that occurred. He tells me that he understands what a serious mistake that is, and that on this occasion, if the court accepts the recommendation, he's going to comply with it fully, will not violate bond. He has probation. He has supportive family who will help him do so, and they have provided letters to the court. Additionally, he does currently have a full-time job at Ford Motor Company.
Yes, I've heard about that over and over again. Your client seems to think that drinking alcohol didn't affect this, and there's some allegation of a malfunction car that caused this accident.
I understand that, Your Honor. I think in any case, regardless of whether he believes the accident was ultimately caused by a malfunction, at the end of the day, he was drinking and driving, and that's dangerous regardless of whether it actually is the trigger of the accident. Mr. Williams understands that. He understands there's no excuse for his drinking and driving. Isn't that right, Mr. Williams?
Yes, sir, most definitely. I know that was the hugest mistake I've ever made, and I take full responsibility for, getting behind the wheel while I was under the influence. That was the dumbest mistake. Like, I should have never done that, and I'm sincerely apologetic for that. Like, I just want to prove to the court that I can do this thing right and just live my life, in sobriety.
My concern is, one, about the fact that you have an excuse for why you got into an accident while you were drinking and driving. And you don't seem to accept that your drinking and driving is likely what caused this, and you're blaming it on a car. My second concern, let me finish talking.
Yes, ma'am. Yes,
My second concern is that not only that, but then after you pled guilty in December of 2023, you decided you would just leave, not come back to court, not handle this any way, shape, or form, and have been gone since December of 23. And then your family keeps writing as if, therefore, you should be given another chance. You've had 2. You've blown them each and every time.
May I speak?
One moment.
Yes, ma'am.
You have a prior case in this court that you still owe money on.
Yes, ma'am.
And it looks like you were recently picked up on another domestic violence, and that's how we were able to get you back in court. So all these folks who are writing to try to support you, what are you doing to support yourself? That's the question I have. And the fact that you were just interviewed yesterday and still do not accept responsibility for your own actions is extremely problematic for me.
Yes, ma'am. I understand. I didn't wanted to come off as if I wasn't trying to accept responsibility. I take full responsibility for my actions. I was just, they were asking me what happened, and I've tried to explain to the fullest extent. I got behind the wheel while I was intoxicated, and my car was messed up. But I know for a fact that's not the reason. That's not the reason why.
What's about your car? Why did your car cause an accident? You're saying the car caused it.
No, I'm saying I caused the accident. I was just, letting them know.
Malfunction. You said there was a malfunction.
No, I was just letting them know. I wasn't like trying to blame it on my car. I'm sorry about how that came off. I take full responsibility for my actions, and I know that I caused the accident due to me drinking and driving. And I'm truly, apologetic for that. I'm sincerely apologetic for that. And, I just want to make this thing right. I want to show my family, I want to show the court, I want to show you that I can actually do this thing correct, and live my life in sobriety, just go to work and continue to take care of my family. I
And
take
keep
full
your hands to
responsibility.
yourself.
I
And
know.
keep your hands to yourself. And keep your hands to yourself.
Yes, ma'am, definitely, for sure.
So was there a malfunction to your car or not?
My car I had bought the car already messed up, but that's not the reason why. I was
Answer
drinking and
my
driving.
question.
Yes, ma'am.
Answer my question. Was there a malfunction to your car or not?
Not while I was on the road, no.
The only reason I'm going to give you another opportunity is because you have kids that are relying on you and you have a job. Because I really don't think you are truly accepting responsibility. I think you're willing to say whatever you think benefits you at that moment, and this is another moment. But you can prove me wrong.
Thank you so much. I appreciate that, and I don't want to sound. Come on, I will definitely prove you wrong, man.
Okay. I hope so. I really do.
Yes,
I
ma'am.
want that.
Yes,
I
ma'am.
want that for you, and I want that for your family.
Yes, ma'am. Thank you.
Because I'm not your mom. I'm not the one. I'm not going to listen to your stories. It's not going to work with me. You need to know that for the next 2 years. You need to get your life together.
Yes, ma'am. And I will wholeheartedly.
It is the sentence of this court that you serve 93 days in the Washtenaw County Jail. Credit for the 7 days that are served, 86 are suspended. You're to complete 5 days for a total of 40 hours of community service. You're going to be on probation for a total of 24 months. You'll be eligible for early discharge once you hit the 12-month mark, and we'll see whether you're doing what you're supposed to be doing and you are not getting in any more trouble. You understand those parts?
Yes, ma'am.
Fines and costs in this particular case for a total of $725, $30 per month probation oversight fee. You're to report to the probation officer monthly via the online reporting platform, and you're to report during the second week of each month. You're to complete an outpatient assessment within 7 days and follow all of the recommendations. You need to complete the MAD victim impact panel within 45 days. There's no use or possession of firearm components, ammunition, or other dangerous weapons. There is or alcohol, marijuana, illegal drugs, and no being in a possession of any of those. You attend 2 AA meetings and 2 NA meetings per month and provide proof to the probation department. You're to drug and alcohol test 1 time per week and any other times as ordered by the probation agent. I will see you again in 90 days, and hopefully you're proving me wrong.
Yes, ma'am. I will.
Okay? That's going to be on October 23rd. 2025, sir.
Okay.
Thank you for giving Mr. Williams this opportunity.
You're welcome. The other case where he has restitution and fines and costs, that's going to be scheduled for that same date on October 23rd, 2025. And that is case number 15 FB 70009. You should be released today, sir. Okay?
Yes, ma'am. Thank you.
You're welcome. You're all set. You need to contact the probation department once you're released so you can sign your probation contract.
Okay.
Mr. Williams, you failed to contact them, you failed to follow through, and you have another warrant, and you will be sitting there.
Yes, ma'am. I understand.
All right. Thank you, sir. Take care of yourself.
Thank you. You as well.
Sorry?
I will put Mr. Squires in with Mr. Rizal because we never.
Okay, thank you. All right, Mr. King. I don't see him on the
Yes, Your Honor.
screen. Do you need, a breakout room with Mr. Leonard?
No, Your Honor, I've spoken with Mr. Leonard prior to the court calling the case.
All right, thank you so much. The court will call the case of the state of Michigan versus Terrence Brown, 25S00188.
Tiffany Woods for the people.
How you doing? I'm here.
Please state your name.
Terrence Brown.
Thank you. We're here.
Sorry.
Go ahead.
Sorry, Your Honor. Allison Mueller here on behalf of Terrence Brown.
Thank you. We're here for a pretrial today.
Yes, Your Honor. There is an offer from Ms. Woods. I have told Mr. Brown what the offer is. At this time, he would just like a little bit more time to think about the case and the offer and decide how he'd like to proceed.
Is August 14th enough time for you to think about it, Mr. Brown?
Yeah. So, yeah, it is.
Or do you want more time?
No, I mean the 14th would be good. Honestly, I think I want to just wait until see if guy doesn't show or whatnot.
Right. I think he's asking for a final settlement conference and rejecting the offer.
Oh no, I'm not doing that.
So, Mr. Brown,
Well-
remember we talked about the complaining witness only needs to show up at final settlement conference. So that doesn't happen at the pretrial.
Oh, okay. Then yeah, I'll just have more time. Then we can speak again.
We'll adjourn. Okay. Thank you.
Pretrial is adjourned to August 14th, 2025 at
14.
9 a.m.
Got a call.
Bonded. You can show up for work, sir, and handle it that way. It's up to you. Bond is continued.
All right.
Thank you. What is Ms. Nybert here on?
This.
Hi, Your Honor. I'm here for Brett Botter. I was here for a motion to set aside.
That person has not signed in. Maybe you need to contact them. So
He was, his mom was is Miss Van Siekenstein. I'm sorry. Van Elstein.
no one is shown.
She said she was signed in earlier. I'm not sure if it dropped. I can tell her to re-sign in. Oh, I'm getting a message from. Oh, nope, there wasn't a message from me. Sorry.
Nybert, the recorder says no one by that name has signed in.
Okay,
Ever.
I'll ask her to sign in again. Thank you, Your Honor.
Mm-hmm. The court will call the case of the state of Michigan versus Cole Leonard, 21S00757.
Tiffany Woods for the people.
Good morning, Your Honor. James King on behalf of Mr. Leonard, who's present via Zoom and consents to being present via Zoom. Mr. Leonard, can you please state your name for the record? You're muted, sir. If you can't unmute, you may have to ask the officers to unmute you.
Cole Leonard.
Thank you. All right, we're here for a violation of probation today. Apparently, Mr. Cole Leonard was arraigned by the magistrate on June 20th. The allegation is that Mr. Cole Leonard was found guilty of operating while impaired on March 9th Is this 2023 or 2025?
I believe it's 2020, found guilty, I believe on 2025, Your Honor.
All right. One moment. So this particular case is a moving violation causing death. And he pled as charged to this on May 4th of 2023. At the time, he also was found guilty of another operating while impaired on March 9th of 2023 in the 20th District Court. And since he's been on probation here, he has a new case that he pled guilty on April 16th of 2025. And that's in Dearborn Heights. So that is the allegation of a violation of his probation, which is a non-technical violation for which he could get his probation revoked, and he would be sentenced to, he could be sentenced to the maximum penalty, which is 365 days in the Washtenaw County Jail. It appears he has 84 days served. He's entitled to have a hearing on whether these allegations are true or not. Do you know what your client wishes to do?
Yes, Your Honor, I believe at this time, Mr. Leonard wants to admit and accept responsibility with explanation.
Let me be very clear. I don't see what explanation would sway me with respect to the recommendation in this case. Mr. Cole Leonard was told at the time that he pled to this case that he had one opportunity to keep it together. He caused a death, and I take that very seriously. So I intend to follow the recommendation, just so you know, Mr. King.
I understand, Your Honor. If the court, what's the soonest date that would be available for a hearing on this matter? Actually, strike that, Your Honor. I would, to be completely candid with the court, there was an allegation that Mr. Leonard did in fact plead to. I'm not sure it would be in the interest of judicial economy or of Mr. Cole to have a hearing on the matter that he's already pled guilty to and accept responsibility to. If the court's only consideration at that date would be as to whether or not the actual allegations in the report are true. I understand the court's position at this point in time with regards to being persuaded by anything that's said by defense counsel or Mr. Cole. I'd ask the court to at least consider hearing us out with regards to the way in which this came about and the things Mr. Cole did prior to having the warrant issued for his arrest. I think that if the court does hear some of those things, it may consider either a lesser sentence or at least an extension of the probation to be allowed to have one more opportunity to show this court that he is able to abide by any conditions set forward.
Mr. King, I will always hear folks out. So that's a given. But like I said, this is a new drinking and driving offense. So it's going to be hard. You'll be hard pressed to change my mind about my decision in this, but I will hear you out. Mr. Leonard, my understanding, you're going to waive your right to have a hearing and you're going to admit to violating your probation by having a new operating while intoxicated case. Is that correct?
Yes, Your Honor.
Please raise your right hand and be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Is it true, sir? You were drinking and driving again and got convicted of that?
Yes, Your Honor.
All right. I find that there's a willing and knowing admission to the violation. Are you satisfied, Ms. Woods?
Yes, Judge.
Mr. King, are you satisfied?
I am, Your Honor.
Thank you. So what is it you want to say on behalf of Mr. Leonard?
Yes, Your Honor. I'd like to make a couple points. One, in fact, that Mr. Leonard had been abiding by all the conditions of this court for a significant amount of time prior to the allegations in this incident. Once he was arrested and released for this matter, he contacted me immediately. And not just for the purposes of legal representation, but also because he needed help and didn't know where to go. And so I pointed Mr. Leonard in the direction of Alcoholics Anonymous and also a therapist for him to see with regards to the issues that he was facing at that time that caused him to relapse. Although this is a driving infraction that included alcohol, I'd like to make a note to the court that the court that's already sentenced Mr. Cole knew of all of his circumstances and the situations that he was facing, also knew the facts of the case, which included another individual inside of the car. There were no allegations that Mr. Cole was driving recklessly or that he had put anyone in danger at the point in which he was pulled over. Mr. Cole also was completely complying with the officers when he was arrested. So the way the process worked out, Your Honor, was after Mr. Cole relapsed and started his treatment, a significant amount of time went by before the actual warrant was sent out for the new matter. And once it was, we went to the courthouse and explained all the things that Mr. Leonard had been doing to not only accept responsibility for his actions, but also to get the help that was needed. Mr. Leonard comes before this court with a tremendous amount of family support. Dare I say, they reach out to my office. And Mr. Leonard and I have been in contact and communication with each other since the early months of this year. I've spoken to either him or someone from his family maybe twice a week at minimum. Since then, since he's been incarcerated, I get calls from his family at least 3 times a week, asking what they can do to support. I know his mom was in the waiting room this morning. I'm not sure if she was able to get in today. I don't see her name listed here, but she definitely was present and contacted me throughout the morning. I tried to echo some of the things I'm telling the court right now to his probation officer when that person found out about the new violation, that removing Mr. Leonard from the treatment that he was getting at this point in time would kind of be detrimental, because regardless of what the court sentence would be, eventually he's going to be releasing the community. And I understand that there's an issue with regards to deterrence as far as sentencing goes. But I think what's most important for someone like Mr. Leonard is the treatment that we had him in and the treatment that he can get if he's allowed to get back to it sooner rather than later. One of the benefits of Mr. Cole is that he is gainfully employed, although he has been incarcerated for, I think, almost 2 months now. He still has a job that is ready and available for him when he is released. If he is released sooner as opposed to later, I'm not sure he still have the opportunity to have that job if he's not released for another 10 months. But as it stands right now, his family and I were able to verify employment if he were to be able to receive such. He also is not only someone who emotionally supports his family, but Mr. Leonard contributes to the bills that his mom is faced with on a monthly basis. Since he's been incarcerated, the family has undergone a significant amount of problems, not just inconvenience, but problems, as would come with anyone who is faced with a significant amount of bills. Mr. Leonard completely accepts responsibility. I mean, I think that's apparent through his actions before the warrant was issued in the new case, And also before the warrant was issued in this case, there was a gap in time between the two. Mr. Leonard had been arrested. Time had gone by. He accepted responsibility while undergoing treatment. Before he was ordered by the court to do so, he was going through treatment. And then he accepted responsibility and was placed on probation in front of that judge in Dearborn. And then again, some time had went by before this court was made aware that Mr. Leonard had another conviction. And so once he had accepted responsibility for that, he was right back into treatment and doing well for a significant amount of time before he had to turn himself in. And he attempted to do so on more than one occasion. He and I actually made arrangements to come down to the court, to the county jail, strike that, Your Honor. So I think it was the precinct we were supposed to go to. And we went down there to turn Mr. Cole in. They told us that the warrant hadn't been received yet, so they didn't have any documentation for him. He had every opportunity at that point in time to flee, to leave, to not accept responsibility. I think at that point in time, we had figured out that Mr. Cole had a job opportunity in Ohio that he was preparing to leave for, and had living arrangements out there as well. Excuse me, but he didn't go. Instead, he waited until the documentation was there for him to be able to get there, turn himself in, and accept responsibility for these actions. I don't think those are the actions of someone who doesn't understand what's wrong. I will submit to the court as well that while we were speaking about the need for therapy, it was the fact that Mr. Cole understood that he had caused the death some time ago that still stays with him. And he knows that it's a problem, and it's something I think needs to be addressed with a tremendous amount of therapy and sessions and maybe even medication, because that's not something that people like Mr. Cole go through on a regular basis, or even see in their lives or the lives of their loved ones. And it's hard for him. I mean, and during this process, he also lost a brother that kind of brought him back to that same place of mind. And so I don't mean to be long-winded, Your Honor. I think that in most cases like these, with this type of case and this type of probation, I would come before this court with different words and just we'd accept responsibility. I would let my client speak, and I may say a few things to the court so that it can be taken into consideration. But this is a case in which I seriously think Mr. Cole is in need of some help. And I'm not sure that can be either assessed or treated with a significant amount of jail time. And so Mr. Cole himself had prepared something that he wanted to say to the court. And I told him that I would hope that the court would be able to hear him out. And if the court had any questions, again, most of the time I advise my clients not to speak, or at least to let me do the talking and say something, and not to answer any questions without at least clearing it with me first. But I think Mr. Cole is smart that the court can ask questions too, if you have any of him, after he makes whatever statement he wants to the court.
Before he speaks, the prosecutor has an opportunity to speak, but I'll tell you this, that the dad was in the waiting room, and maybe the mom was at some point too, but people don't come into this courtroom. That's not how it works. If they wanted to provide any additional documentation to the court, it should have been submitted through a letter. So they don't come in. They can watch it on YouTube, and the father was let in once we knew who he was. He was told that he needs to watch it on YouTube. He has subsequently tried to come in again, but he will not be allowed into the virtual courtroom. If it was an actual courtroom, it would be the same thing. We don't typically have parents come in speaking for adults. If they want to submit something for the court's consideration, it has to be in written form. Ms. Woods?
Thank you, Judge. Judge, it's clear this defendant is a danger not only to himself, but to the public. He killed someone. He was driving 90 miles per hour on his cell phone. He had 6 previous crashes before that. Now he has 2 OWIs. We've tried to get him help through probation in this court. He missed numerous tests, tested late. You know, I agree. I think he's in need of inpatient treatment, but we can't force him to get sober and make good choices. And he's not making good choices, and he is a danger. He should be in jail. If the court is to release him after any substantial jail time, I would ask it to be to inpatient treatment. Because he's shown this court time and time again. I mean, how bad does it have to get? He's already killed someone. I don't think it gets any worse than that. He is an absolute danger, Judge, to everyone out there, based on his substance abuse disorder that he refuses to get help for, and his poor decision-making, Judge. I mean, this is a hard one, Judge. I'd leave it to the court's discretion. Thank you.
May I say one last thing before the court hears from Mr. Cole, Your Honor?
Certainly.
And this may be doing a little bit too much, but I'd be remiss if I didn't at least mention this case kind of, the reason why I took this case is because it kind of hits home for me. I had an uncle who was doing well, who had no allegations of alcohol when he had an accident. He killed a little girl and lived with my family and was a raging alcoholic for over a decade because of it. And the way the courts addressed his situation was a month out, a month in, months in, months in, a few months out. He never really got the treatment that he needed. And so it lingered with him until he remarried almost 2 decades later. Mr. Cole's situation screams at me the same things that I saw in that man, and that being that obviously what happened with Mr. Cole was an accident. And it is something that sits with him and something that he has to deal with all the time. I don't disagree with the prosecutor with regards to the fact that he needed to understand that what happened is not okay and be punished for it. What I'm asking the court is, I understand that it would be somewhat a slight to the decedent in this case to just slap Mr. Cole on the wrist and say, hey, no harm, no foul, go home. And I understand that he has at least 10 months left with regards to his probationary sentence. I'm asking the court at this point in time to give him the inpatient treatment right now as opposed to jail time. And for the same reasons that I believe he's going to explain to the court when he gets a chance to talk. But he is going to be released at some point in time, Your Honor, back into the community. And so I don't think 9 months of jail and 30 days of treatment is going to do the things or undo the things that have been done here in this case. And at that point, I digress. I'm sorry if I did too much. I let the court hear from Mr. Cole.
Well, actually, I wanted to say something to you, which will maybe inform Mr. Cole's statements to me. As we sit here today, he is sentenced and standing in front of this court on a moving violation causing death, having it appear as though it was an accident. And it was an accident. There's no question that it was an accident, but it wasn't a standard accident. Mr. Cole was doing 90 miles per hour, texting and driving. And the truth of the matter is that there's no proof of it, and that's why it wasn't charged this way. But when you review the report, it appears that there could have been drugs involved, but unfortunately, based on the investigation, that wasn't checked properly at the time. That is one of the concerns that I had. And to be doing 90 miles per hour while you're texting in and of itself is a problem. Sometimes accidents happen. You make the wrong turn, you miss the light. But this was speeding down the highway, 90 miles per hour while you're texting at the same time. That's not just an accident. That is extremely poor decision-making that caused a loss of life. And I've heard an awful lot about how his family is affected. My concern at this point is for the future of families to come, as well as for the family of the man who is now deceased. And I think it was a man. That part I can't remember clearly. The loss and the way they are affected can never be fixed. He was given a second opportunity to try to show out of respect for that man, that person, that human, that he was going to get his life together. And instead, we're sitting here with another charge of getting behind the wheel, endangering the lives of other people. It's the nature of the offense that he committed. That is the reason why I'm so challenged to do anything other than give him the time. Now, Mr. Leonard, haven't heard what I have to say. What do you have to say?
Mr. King pretty much said a lot of it for me, but I am very remorseful for what happened in 2020. And yes, it has been on my mind every single day for the past almost 5 years in October. And I'm ashamed and embarrassed to say that I didn't learn my lesson the first time. But I believe and I know I learned my lesson this time. Yes, I have been seeking therapy. I've been doing meetings. I've been doing everything I can since this happened and actually taking it seriously and trying to take the steps to become a better person mentally and get the help that I believe that I need. And ever since actually taking these steps and taking them seriously, I have felt truly better mentally about things these past few months than I have the past 5 years. And I'm truly sorry. Basically, that's no, I wrote a bunch of stuff down, but yeah, thank you for hearing me out, Your Honor.
Listen to what you wrote down, Mr. Leonard.
What is
It's your
it?
life. I'll listen to what you've written down. It's your life. I take every piece of this very seriously. Every piece of it. Your life, their lives, the future of everybody. You getting the help that you need. Like your attorney said, that's the most important thing he said today, is that at some point in time, you're going to get out. And if you get out and you don't have the treatment that you need and you haven't really changed, then that's the danger too. So all of that is what I'm taking into consideration.
I do want to change. I do want to get the help that I need.
You want to try to read your letter, Mr. Leonard?
Twice. It's all over the place, this letter. Started to see a therapist after my second OWI in March, and I've been seeing one every Monday for these past couple months after that happened. And up until I had to come in here, I wish I would have started seeing her years ago after after 2020, what happened, because I really feel like my life would be a whole lot different right now if I did. These past few months between the AA meetings that I have been attending, the times I started going to church and all the meetings with my therapist, I believe genuinely changed me for the better and have been changing me for the better. Even though me being in here and the bad news I've gotten these past few weeks, besides all of that, I have never felt better about myself and better mentally and more motivated to get better, to keep getting better than I have since the accident happened in October. I started to have hope. I started to believe. I started to feel motivated and determined to get back on track and become a better person. I started to genuinely feel happy. Even though I had this going on still right now, I felt like things were kind of starting to fall in place for the better. Before I came in here, I was taking the steps in becoming a better person, and I believe I truly did learn my lesson this time, and I haven't been more motivated and determined to become a better person, to make something of myself and to make my loved ones proud. I have goals for myself now, and I'm ready to get better, get out, and tackle these goals. I'm done feeling embarrassed and ashamed and unhappy, and I have hope that this time around things will be different and they will be better. I'm excited to get out and continue to change for the better and have a career and be with my family. And get out and help my mom as much as I can. That was some of it. I don't know. Thank you for letting me talk, Your Honor.
I think that you need to go into long-term inpatient. And the only thing I'm mulling over in my head right now is whether I'm revoking your probation and sending you there with a long-term jail sentence, or whether I'm gonna reinstate your probation, leave you in jail until you're released to inpatient, or your family finds inpatient. I believe that you are finally trying to deal with what you did. And it's probably one of the hardest things that anyone has to come to terms with as a human. My choices have to reflect protection for the community and value for the life that is lost at the same time, while giving you what you need to be a better human in the future. So it's really hard. Because so far you've proven to me that you really haven't been able to do that. Maybe since this last incident, you are making those steps in the right direction. But becoming a productive person for you is going to be extremely challenging. I think you need more assistance than you have right now. So what I'm going to do is a moment. I am going to revoke the probation. I'm going to sentence you to 365 days in the Washtenaw County Jail. You're going to be given credit for 84 days that you've served. $281 days to be served. You may be released to an inpatient treatment program. As soon as they find a bed available. That's a long term. That's not 30 days. That's 90 days or more. And they come to me before you can get released. So make sure it's 90 days or more. If you leave treatment, then you will have to finish the rest of your jail time. Do you understand, sir?
Yes, Your Honor.
I know it's not the outcome you want, but it at least allows you to get into some treatment.
Thank you. I really appreciate it.
As I said, I will assign, you should talk to people over at Inmate Services. Patrick Treep is the person who makes that decision. Mr. King, you might want to make phone calls so that they can find him a treatment. As long
Patrick,
as
I
it's
think that's the
learned.
last name, Your Honor.
Treep, NACHTRIEB.
Thank you.
Mr. Leonard, I wish you the best, and I hope that you take advantage of this opportunity, sir.
I will. Thank you.
Thank you.
Thank you, Your Honor.
The court will call the case of the state of Michigan versus Brett Bowder, case number 16 FB 1496.
Tiffany Woods for the people.
Rebecca Nybert serving on behalf of Mr. Brett Botter. Mr. Botter, can you please state your name for the record? Oh, Mr. Botter, you're muted.
Hold on. Okay.
Brett Lewis Botter.
Thank you. Can I see counsel in the breakout room?
Yes, Your Honor.
Okay. Full name, just go ahead and mute yourself until your case is called. I don't know. I want it to be counselor. Shout. Okay. Just wait. Because, I mean, it's not. It's all the way up. I think they're trying to get those.
It's done.
No, your lawyer.
Hi.
Mr. Bowder,
Yes.
hear you. If you could please record, put it on mute until they call your case again, please.
Can I mute?
Yes, please.
All right. Where's mute?
I know that.
Where's
I
mute?
think we should try to get it on the computer.
Want to leave?
Huh? No. Just let me call her. Call her. Tell her.
S00265.
Could be what's for people.
Mr. Amadou Diane, please unmute your device, state your name and who's representing Mr. Diane.
Amadou Diane.
She in here?
She is.
Miss Muller.
Drops again. When was he at full circle? When I got picked up here.
Your Honor, he did report during the precedence investigation that he was at full circle when he was picked up for the warrant that he had on the indictment. But that is self-report. We don't have any verification of that.
Do we know if he was drug tested when he was arrested?
Your Honor, I was looking for that information in the report and I could not locate it either.
Were you drug tested when you were arrested?
Yes, I had nothing in, except for abuse of porn. It's from my supplicate shop.
Is that accurate? Buprenorphine would be in,
Your Honor, I don't see that it is recorded in the pre-sentence investigation, his drug test result when he was picked up on his warrant.
do you have a valid prescription for buprenorphine? Do you know? Does anybody know?
I believe in the PSI, it does state that the drug or the jail has him on a valid prescription.
Your Honor, Sublocade also will cause a positive drug test for Suboxone for quite some time after the last injection is administered.
And he's on the injection now?
Yes.
That's what he reports, Your Honor. The jail does not administer Sublocade, they only administer Suboxone.
Yes. So I have not been on that this whole time. Man, get some tissue.
Where do you live, Mr. Hanson?
I was living at the Full Circle Sober Living House, sir. Yes, ma'am.
Your Honor, I can confirm that he was not drug tested by our department when he was picked up on this most
He was
recent.
not?
He was not. The last drug test that we have is from November of 2024.
Or was it positive then?
I believe it was negative at that time. It was negative at that time.
Okay. All right, Mr. Hanson. I'll make a finding today that you're amenable to community control, although I don't know that I fully believe that. We'll place you in community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from use of any drugs or alcohol, and this includes marijuana.
Yes, Your Honor.
I'm telling you right off the bat that one violation, you're going to prison. I'm not going to fool around with local jail time. You're just going straight to prison for 12 months. Do you understand that?
I do, Your Honor.
So you're going to be placed on electronically monitored house arrest and sent back to Full Circle.
Yes, sir.
But you get kicked out of Full Circle, you test positive for any illegal substance or alcohol or marijuana, you're going to prison. That's
Yes,
it.
Your Honor.
You understand that?
I do understand.
Court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You get 64 days jail time credit. You're also subject to a discretionary post-release control, which means that if I do send you to prison upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Mr. Harris, is there anything else?
Finding him indigent for purposes of.
Yes, I already said that.
financial statement.
Anything else?
No, Your Honor.
All right, your only reprieve, Mr. Hanson, you got this one opportunity and that's it. And it will be in my notes. The same with you, Mr. Merritt. I've already put in last chance on my notes here. So when you come back before me for any violation, you're going to prison.
I won't be back.
Clear?
Clear.
All right, that's all.
Thank you.
Mr. Clark, you guys can step with the podium.
Afternoon, Your Honor. Good afternoon. Case number 25CR42418, the State of Ohio versus Autumn Bryant. Ms. Bryant is before the court with her counsel, Mr. Clark. Mr. Harris, on behalf of the State of Ohio. Mr. Harris.
Your Honor, we've had pretrial discussions in this matter. I believe we have reached an agreement. My understanding is the defendant is going to change her plea to guilty. That would be to count 2 of the indictment, assault, misdemeanor of the first degree. And in return, if that is done, the state has agreed to dismiss count 1, which was strangulation felony of the 5th degree. I did have conversations with the victim in this matter, and she was in agreement to proceed in this manner.
Mr. Clark, is that accurate?
That's accurate, Your Honor.
All right, Ms. Bryant, they're telling me you're going to change your plea to guilty to 1 count, 1 amended count from the indictment. No, I take that back, just 1 count, the misdemeanor count. What happens then is the court accepts your plea. I'm sorry, the court, I did need to go over some things with you. All right, how old are you?
I'll be 25.
How far did you go in school?
High school, graduated.
Can you read and write?
Yes.
Are you a citizen of the United States?
Yes.
Does anyone promise you how this court would sentence you?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation you've received from Mr. Clark?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on here today?
No.
I have in front of me a document that's called a change of plea. On the second page on the line mark defendant, there's a signature. Did you sign this?
Yes.
Did you read it and go over it with Mr. Clark before you signed it?
I did.
And you feel like you understand what it says?
Yes.
This document says you're entering a plea of guilty to 1 count of assault as a misdemeanor of the 1st degree. That carries a maximum penalty of 180 days in the Warren County Jail and a $1,000 fine. Do you understand the maximum penalty involved?
I do.
You're also subject, don't strike that you are not. It's not a felony. So you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that? You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or they are required to find you not guilty, and their verdict must be unanimous. Do you understand that?
Yes.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes.
You have a right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, Your Honor.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes.
The standard of proof is beyond a reasonable doubt. The standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes.
Do you believe you understand each of these rights we've discussed?
Yes.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We're not going to have a trial.
Yes.
This is how you wish to proceed.
Yes, Your Honor.
All right, Mr. Harris.
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count 2, that on or about January 30th of 2025 in the city of South Lebanon, Warren County, Ohio, the defendant Autumn Bryant did cause physical harm to another. Specifically, this was at Bernie's Place Shelter. She engaged in a altercation, verbal, which turned physical, and wherein the victim in this matter, Nicole Bass, sustained injuries to her neck and chest area. These were some deep scratches.
Mr. Clark, anything on those facts?
Nothing on the facts, Your Honor.
Ms. Bryant, did you hear the statement that he read?
Yes.
Do you admit and acknowledge what he said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
I do.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court accepts your plea of guilty. And based upon the statement of facts in your plea, the court will make a finding of guilty. I'm going to order a pre-sentence investigation. Let's make it a level 3. Let's come back in a few weeks and do sentencing, okay? You need to go back down to court services and schedule your interview. And if you'll go see Jennifer and schedule it for a sentencing hearing.
I got it, Your Honor. And that was going to be my request as well, that we have a pre-sentence investigation done as quickly as possible. I think we had a trial date scheduled in September. The defendant's had quite difficulty. She's found 2 or 3 jobs in which she's gotten the job, and then a couple days later on a background check, they found the felony charge, and she wasn't able to keep the job. So we'd like to move this along as quickly as we can.
Okay. All right. We'll see everybody in a few weeks.
Thank you.
Thank you.
Thank you.
Mr. Clark, just let Ms. Yates know it's a level 3.
Okay.
She didn't hear.
Okay.
Look.
The right to question any witnesses the state would have against you.
Yes, sir.
And finally, I understand you're giving up the right to have the state prove beyond a reasonable doubt you did in fact commit these offenses.
Yes, sir.
Okay.
probably just police narrow into it.
Okay, so police report states that on July 23rd, you ran your vehicle into a fence. You agree with those facts?
Yeah, I admit to that part, yes, sir.
Okay. And then when officers found you, you appeared to be under the influence of alcohol. Do you agree with that?
They came to my camper. I was not even driving.
Okay. Was that a yes or a no?
What was the question, sir?
You appear to have been drinking alcohol or under the influence of alcohol.
Yes, sir.
Okay. And then you took a horizontal gaze nystagmus test and refused a chemical test. Is that correct?
I don't remember refusing since I did the horizontal gaze nystagmus.
Okay. It said you refused to. It said you refused to sign the BMV form about the chemical test. Is that correct?
I don't even think I was.
Your signature's not on there.
Yeah, I don't think I was
Okay.
offered.
You don't think you were offered? Okay. Okay, but based on the police report and the ticket, I'll accept your no contest plea, find you guilty. What did you want to say today?
Just pretty much already did. I was not driving under the influence. I was at my camper drinking when the deputies arrived.
Okay. Did you want to plead not guilty today?
I'll stay with no contest.
Okay. All right. Are you staying at the campground?
Yes, sir.
How long are you there?
Yeah, originally was going to stay just until the 17th of August. Yes, sir.
Okay. All right. You live in West Virginia?
Yes, sir. I'm just up here coaching American Legion baseball.
Okay. So you're going to be here at least until the 17th, you say?
Yes, sir.
Okay, here's what I'm going to do. I'm going to set a sentencing hearing. I'm going to release you on your own recognizance today. You understand that?
Yes, sir. I greatly appreciate it.
Okay, well, make sure you know when you're supposed to be here for your sentencing hearing, okay?
And when will I get that, sir?
It'll get scheduled here in the next couple weeks.
Okay, sir.
All right, thank you.
Yes, sir. Thank you. All right.
All right, as you heard me tell those folks, today's hearing is being recorded. Anything you say can be used against you in the future. You have a right to an attorney. If you can't afford one, you can make an application today for a court-appointed attorney. When I call your name, have a seat at the table. We'll go over your charge and your plea, and then you need to go to the clerk's office. Next matter is 25 TRD 478, State of Iowa versus Ronald Snyder. Yeah, at least here on behalf of Mr. Snyder. Okay, I have a ticket from January 17th charging Mr. Snyder with driving under suspension. Did he receive a copy of that?
Yes, Your Honor. This time I waived reading of penalties or anything of that nature.
Okay.
An inner plea of not guilty.
All right. Looks like M4, correct?
It's correct, Your Honor.
Okay, where you living, Mr. Snyder?
365 Lady Street.
Okay. And what happened that you couldn't make it to court?
Didn't have a ride.
Okay. All right, you gonna be able to get here if I let you go today?
I walked.
Yeah, from Eddy Street? Okay. All right. Does that mean you can get here?
Yeah.
Yeah. Don't have to keep you at the jail. All right. Okay. All right. Thank you.
Thank you, Your Honor.
Come with me.
Next matter is 25 TRD 5261, State of Iowa versus Sarah Avery. Ms. Avery, I have a ticket from June 7th charging you with driving under suspension. Did you receive a copy of that?
Yes, Your Honor.
Maximum penalty is 500 hours of community service and a $1,000 fine. Do you have any question about that charge?
No, I do not.
How would you like to plead today?
Guilty.
Okay. You understand that a guilty plea is a complete admission of your guilt?
Yes.
You understand you're waiving your right to a trial today?
Yes.
Accept your guilty plea, find you guilty. Did you want to say anything?
Just that I'm not complying with not driving. I'm homeless, so I'm in my car. I was staying at the domestic violence shelter, And we left, and I have 2 kids. So they've been staying between Columbus and Newark until we find a place here. But I'm the only parent that's able, my son is the center for Newark's football team this year. So he's got football practice every day. And then my 11-year-old also has football. So I'm just I try to have somebody else drive as often as possible. But there are times when there's nobody available.
So where are they staying?
Either at their brother's house in Columbus, and then we have friends. The address on Mount Vernon Road is a friend of mine. It's just not conducive to children, so I don't like to take them or have them stay there, but it's at least somewhere we can go in the meantime, or I can wait between practice and pickup time.
What's going on at the BMV? You know, have you checked into?
I got a letter because I was an inch away from getting my license, and then when all the letters came out and everybody's license got reinstated, I got a letter that said I had to wait a year. So I don't know if
you have some reinstatement fees to pay,
Mhm.
And then you need an SR22.
But I don't have to wait for a year.
Let's see. What did they tell you? I can look you up here and see what.
I thought that the letter, like from the court, was stating that because I got caught driving under suspension, I had a 1-year.
You might have some hard time where you're not allowed to drive because you've had non-compliance suspensions before. Do you have an ID card?
Yes.
Okay. So you have to get it. I mean, you'll have to test and all that stuff to get your driver's license. So you're suspended through April next year. And then you have reinstatement fee on the 12-point and on the old OVI suspension, I think. So you need an SR22 to get in compliance with the non-compliance suspension, and you'll have to keep that through 2030, it looks like. And let's see here. Yes, $1,760 in reinstatement fees. They have payment plans. They have an amnesty plan if you want to check into that. You got some warrant blocks in here and in Fairfield County. You should be able to get those lifted by asking, but I don't know the answer to that unless you actually do have outstanding
No, I don't.
warrant issue in Fairfield County. So yeah. Okay, it looks like did you apply for amnesty?
But I didn't apply for the hardship part of it because I was waiting to do
Yeah, so this says pending amnesty fee payment plan. You need obviously proof of insurance and a new license. So yeah, pretty good list of stuff, obviously.
What do I start with?
That's a good question. If you want to make an appointment with probation department downstairs, they can help you with that.
Okay.
Because the BMV is not the easiest to work with. So, so one of our probation officers would get you started in the right direction. Because you need to do that. You can't be driving. I mean, you're gonna be in jail probably the next time I see you. It's a jailable offense, and you've got like 5 of these in the last four years, I think. So, and, you know, obviously it just gets harder to get your license back the more you pile it up. Can you see balance? Okay, 115 court costs. Get down to the basement before you leave and make an appointment, okay?
Okay,
All right.
thank you.
Next matter is 25 TRD 6393, State of Ohio versus Marvin Owens. I have a ticket from July 8th charging you with speeding, driving without a license, and failure to wear a seatbelt. Did you receive a copy of that?
Yeah, I think they did give me a copy.
Okay. Penalty for a seatbelt is a $30 fine. Maximum penalty for driving without a license is 500 hours of community service and a $1,000 fine. And speeding has a maximum penalty of a $150 fine. You have any question about those charges?
So for the seatbelt, I had took it off when I got pulled over.
Okay.
But other than that, no.
Okay. How would you like to plead?
Guilty.
You understand that a guilty plea is a complete admission of your guilt?
Yeah.
You understand you're waiving your right to a trial today?
Yeah.
I accept your guilty plea, find you guilty. Are you able to get your license?
Yeah, I had just moved here like a month ago.
Okay.
From New York.
From out of state?
Yeah.
Okay.
So a lot of times I'll be busy with either work or
Okay.
my child.
Yeah.
And I don't have a car throughout the day because my mom be at work. So
Okay. Yeah. You gotta get a license. I mean, yeah, you get caught driving and it puts you in the hole, for a lot of money. It's expensive, hard to get out. All right. $30 seatbelt, 34 speeding, 125 court costs on a license. Thank you. Next matter is 25 TRD 5484, State of Ohio versus Joseph Aaron. Mr. Aaron, you missed your trial. What happened there?
What did you say?
You failed to appear for the trial.
Yes, I called in and then he told me to send in a letter for him.
Yeah.
So I did send in a letter because I started a new job and he never gave me permission to. I asked for permission.
Okay.
It was hard for me. And I received a letter back. I was denying for them. So I called in within a week to speak to the attorney.
Do you want this reset for a trial?
No.
Okay. You want to plead to it today?
Yes, I want because my job is very restricted.
Okay. You just want to pay the ticket then?
Yes.
Okay.
Come with me.
Are you able to pay it today?
Yes.
Okay. Next matter is 25 TRD 3868, State of Ohio versus Rachel Bauer. Good afternoon. I have a ticket from May 5th, charging you with a electronic device violation. Did you receive a copy of that?
I did.
Okay. Maximum penalty. Let me check here first. You haven't been convicted of that before, have you?
I'm sorry.
Have you been convicted of that before? Doesn't look like it. Okay. Maximum penalty is a $150 fine. You have any questions about that charge?
No.
Okay. How would you like to plead today?
Not guilty.
Okay, you'll be set for trial here relatively quickly, okay? All right, thank you.
Come with me.
Next matter is 25 CRB 841, State of Ohio versus Benjamin Strawn.
So, I don't.
Come on.
Okay.
Yeah.
She's getting it.
You're putting there? You're putting, somebody what?
That's not, it's the girl in the dress, you're gonna grab it, leave it in there?
Yeah, give it to the bailiff. All right, Mr. Strawn, I have a complaint here charging you with theft. Did you receive a copy of that? Okay. Do you need me to read?
I got the ticket in the mail.
Okay.
The sums.
Yeah. Do you need me to read that to you? Maximum penalty is 180 days in jail and $1,000 fine. Do you have any question about that charge? How would you like to plead today?
No contest.
Okay. You understand that the facts in the complaint are sufficient to convict you of that offense? I'd find you guilty today.
What is it? I about lost my wife over my drink, and I currently checked myself into treatment. So,
Okay.
I mean, and I just don't. I mean, where was this?
Okay, this is Walmart on
As some lures for my son's birthday.
May 30th. Walmart, it's alleged that you took a you switched price tags on air mattress. Okay. Any other questions about that? No.
Questions?
What's that?
No questions.
Okay.
Is there any way possible of me doing some kind of a diversion program with me getting things together?
Not if you've been convicted of offense before. You could apply for intervention if it's an alcohol problem or something like that.
No, I mean, I've been clean for 3 months.
Yeah. Okay. That wasn't going on at the time of this.
That it was right at the end
Okay.
of this.
Yeah. So if that's what was going on, you could, that's an option if you wanted to apply for intervention. You'd have to go get an assessment from LAP in order to, they can tell me that you're qualified for that. Would you like to do that? Okay.
I can go all the time. And then I'll send you downstairs.
Is this all you have?
Yeah, that's all I have.
Okay, I have you checked in on it. I've got just a few more people. Let me bring them in and we'll start moving.
Thank you.
Yep. Good morning, Ms. Bourne Fisher. Good morning. Hi, good morning, Council. Can you tell me what you're here on this morning? I'm going to check you in.
Yes, I'm here for Portfolio Recovery Associates.
All right, I have you checked in. I've just got a few more people. We'll get going.
Okay, thanks.
Good morning. I have Sandra Thompson in the courtroom. Ms. Thompson, can you unmute? Ms. Thompson, I want to make sure everything works before I start calling cases. I'm asking you to unmute.
I think I did.
Oh, there you are. Okay, you have the audio on. Can you try and turn your, there you are. All right, Ms. Thompson, you're up and running, you're Zoom ready. Give us just a few minutes. I have you checked in, okay?
Okay, thank you.
Thank you. Good morning. I have someone in the courtroom. It says Gary's iPhone. Can you unmute and tell me your name? Gary's iPhone.
Yes, that's me, Lisa Dixon. Gary is my fiance that also lived in the apartment. And he is here with me.
All right, I'm going to change your name. I've got you checked in. Give me just a few minutes, okay?
Sure. Good morning, Your Honor.
Good morning. All right, Mr. Bagg.
I'm sorry, did you say Bankstein?
Oh, yeah, I'm sorry. Yes, I'm trying to see what you're here on. 07. Are you Crown Asset Management?
That's
Mr. Banks?
correct, Your Honor.
All right, I have you checked in.
Thank you so much.
Yep, I just have one or two more people. Well, there are 3 in the waiting room. I'm going to check them all in and then we'll start calling. All right, good morning, Mr. Bagg.
Good morning.
Hey, I see what you're here on. I've got you checked in, okay?
All right, thank you.
2 more people and then we're going to get going.
All right.
Good morning, Miss Ellis. Can you hear me? Miss Ellis?
Hello.
Oh, I'm sorry. I saw Sharon Ellis. Is this counsel?
Yeah, Judge Sharon Ellis is here with me. I'm her
All right, sir.
attorney.
Counsel, what's your name?
My name is Joseph Lucas, Lucas. I did file an appearance.
Okay, it might not have made it onto the docket yet.
Right.
So I've got you checked in. I've got one more individual and then we'll get going.
No problem. What court is this?
Mr. Cardis?
Yes.
All right, good morning, sir. I have you checked into court, okay?
All right. Good morning.
Good morning.
Your Honor, could you put Mr. Cardis and I in a breakout room? Maybe we can settle this.
All right, perfect. Mr. Cardis, the attorney for Citibank would like to meet with you. I'll put you 2 in a breakout room, okay?
Okay, thank you.
All right. And I have Portfolio Recovery and Sharon Ellis here with her counsel. Would the 2 of you like a breakout room or the 3 of you?
Yeah, that would be very useful, Judge.
All right, we'll put you in a breakout room. Give us just a second, okay? All right, I also have the parties on Lisa Dixon and Harvest Investment. Would you like a breakout room so you can discuss this matter before I call it?
Sure.
All right, so I'll put you in a breakout room, Ms. Dixon. We'll put you in a breakout room with counsel. And then when you're done discussing the matter, you could just come back out, okay?
Okay.
Morning.
Good morning, Your Honor.
Give me just a second, and I'll swear in your witness. We have Crown, and I have Sandra Thompson here and Mr. Bankstein for Crown Asset Management. Would you like a breakout room so you guys can discuss this before we call the case?
That's fine.
All right, we'll put you two in a breakout room and we'll see you back in just a few minutes, okay?
Thank you.
Thank you. Mr. Burke, I'll call yours in about 10 minutes.
Thank you, Your Honor.
Okay.
Westminster Harvest LLC did file a counter complaint back in May of 2025. It's been 2 months. We haven't received an answer at all to the counter complaint. I did submit a default after the 28 days to the clerk of the court to sign.
Okay,
no
well,
fruitful answer.
all right, Mrs. Dixon, there was a counter complaint filed against you. You have to file an answer to that.
Okay, I don't remember receiving a counter complaint in May.
Ma'am, we don't have a lawyer, obviously, you know, so we're doing this by ourselves. So we're trying, I guess what we're at this point, we're asking for a little bit of time to make sure we do this right. Obviously, you know, the property management company, you know, these are the tactics they use to try to force us to hire a lawyer and all that. So I guess what we're asking for is a little bit of leniency with the court. I will file the motion for amendment, whatever I need to do.
Sir. Listen, Lisa Dixon's named on this complaint, not you. So I have to, I know that you two might be working together and I understand you resided in the home together, but I need Miss Dixon to be present as well and interact with here.
I am here, Your Honor.
All right, so Miss Dixon, they filed a counter complaint against you. You can go online and find a standard answer. You just admit or deny the allegations in that. You are improper. You don't have a lawyer. The court rules don't say I get to be, and don't take this wrong, but I don't really have the ability to just say, well, they're improper. And I understand the frustration with that. And so they don't have to follow the court rules. You do, but look, she also they're in pro per. They filed a small claims case. It was moved out of small claims. I'm going to give them a little bit of grace. They've appeared today. I'm setting aside the default. And I'm giving them 2 weeks for Dixon to file answer to counter complaint, okay?
Okay.
So ma'am, if you don't have a copy of that, do you have a chat function? Miss Dixon, look, down there in the chat, can you see where the chat is?
Yes.
Okay, I'm gonna send you an email that you have to send your answer to, okay?
Okay.
And are you saying you don't have a copy of the answer?
That is correct.
All right. If you can type an email back to me, I mean, I can have the clerk send you a copy.
Okay. Did you want me to put my email address in this chat room?
Yeah, I'd like you to put it in the chat. We live stream, and I don't like the people that give all of their information out to me. I'd rather you type it in because that's more private.
Thank you. I appreciate that.
This is all just together. And we'll get you a copy of that today. All right. On Crown Asset Management, I'll be right with you. Give me a second. A second. All right, and then I'm inclined to set a scheduling order while we're here. I understand she has an answer due, but I don't see any reason to bring everyone back in 2 weeks to find out if the answer is filed. Ms. Dixon will file that answer. So I'm going to set a scheduling order on this.
Okay.
It means I'm going to give you both dates, and those are the dates you are to have certain things completed by. I don't know how much, counsel, do you believe you need any discovery time?
Your Honor, they're alleging they have a bunch of photos and other documents. So I would like 60 days discovery. I would also ask that the pleadings be amended to the correct parties. I've looked up Harvest Investment LLC. I have no indication of who that actually is. They also filed a document as to West Harvest Minister LLC. I also don't know who that is. Harvest Investments LLC did appear in Laura, but they're not a related organization.
All right, who is the proper party?
It should be Westminster Harvest LLC. That's who the contracts are between.
All right, so Ms. Dixon, what you have to do is file the same answer or the same complaint you already filed. You know what? She filed in small claims. Ma'am, do you have any objection to amending this file to have the correct defendant, which is Westminster Harvest LLC?
No.
All right. Well, I'm going to grant that. All right. So we'll have the party corrected to Westminster LLC, Harvest LLC on stipulation of the parties. We'll get the counter complaint answer within 2 weeks. And again, Ms. Dixon, you can find those forms online. You come to the court, we have blank answer forms here.
Okay.
All right, I'm going to give 2 months for discovery. Discovery will end on September 25th of 2025. Discovery is a period where the parties must cooperate to exchange information and documents. That means Ms. Paglia can send you questions called interrogatories, and you can answer those. You have to answer the questions. If she asked you to produce photographs or anything of that nature, you have to produce them. And similarly, Ms. Dixon, if you have questions you want answered about who did the flooring or what was the reason for the need for new flooring or whatever kinds of questions or photographs, documents, you can ask her for those things, okay?
Okay.
And they're called interrogatories. You could probably look them up online and see what they look like too. And so you have to submit everything and exchange everything by September 25th to 25. There will be no depositions. That means you're not going to take, they're expensive. We're not taking sworn testimony because the dollar amount does not necessitate it. And I have control over the amount of discovery allowable in a district court case. I'm also not allowing requests to admits. No requests to admits. Ms. Dixon, that doesn't mean much to you. It means something to the attorney. Okay? You can ask each other questions. You can ask for documents, but that's the extent of discovery on this case. Witness lists. You each have to file a witness list of your witnesses, people who are going to come and testify if this matter went to trial. And your witness list will be due on October 9th of 2025. And if you file a motion for summary disposition, that means there is no issue of material fact and one of you should win as a matter of law. If either of you are going to file a motion like that, it has to be filed by October 23rd of 2025. Those motions must be answered. By November 6th. So if you receive one of those motions, you must answer it because if you don't, the other party wins. So if you receive one of those motions, your answer is due by November 6th. Any and all adjournments, agreements, stipulations must be done by tendering a signed stipulation and proposed order to this court. All dispositive motions and your settlement conference will be held on 1 second. All right. All dispositive motions and your final settlement conference will be on November 20th of 2025. So if you file a motion for anything other than a discovery motion, if you file a motion for summary disposition, make sure you say the date of that motion or precipice it for November 20th because all motions will be heard on that date, okay? And we'll make sure you both get a copy of the scheduling order in the mail so you have all these dates in front of you, okay?
Okay.
All right, we're all set. Thank you.
Thank you.
Judge.
Amy, can I get some sticky notes from you? I want to make sure I can send something to them so they know what to send. Thank you.
We can delete Judge.
Yep, you're all set.
Thank you.
I lose? Wait, I think I gave him the document. I did. All right, well, I'm taking it back. Okay, that one's done. Then we've got. All right, this is 25010766 Crown Asset Management versus Sandra Thompson.
Good morning, Your Honor. Michael Bankstein, P697778 on behalf of Crown Asset Management.
Good morning. And Ms. Thompson, good morning. Can you tell me your first and last name?
Good morning, Sandra Thompson.
All right, counsel, I saw there's an agreement. What are the terms?
We're at the damages $3,809.46. Court
Oh, you
costs
talk way too
100.
fast for me. You talk way too fast. $3,800.
$9
Okay,
and 46 cents.
okay,
Cost in the amount of $123
okay.
and 10 cents. Plus
Okay.
the statutory fee of $75.
Okay,
For a total of $4,007 and 56 cents.
okay,
To be paid at the rate of $80 a month
80,
until paid in full.
$80 per month.
Until paid in full.
Gotcha. And this is a
Did you
consent.
want us to?
What's that?
Did you want us to email the consent judgment to the court, e-file it? How did you want us to get that?
You now have to e-file it.
Okay, great. We'll just do that once we get the signatures.
All right, so Ms. Thompson, let me ask, does that accurately describe the agreement the two of you came to?
Yes, Your Honor.
Okay, do you have any questions for the court before you enter into this judgment?
I do not.
All right, I'll accept that consent judgment then, and we'll just wait for the paperwork to come in the mail. You're all set.
Very good. Thank you.
Thank you. Have a great day, Your Honor.
You too. All right, let me get your file, Mr. Burke. 5002. All right, this is 240150002 GC. Dr. Harris Burkill versus William Stahl.
Thank you, Your Honor. Hal Burke, P69068 for the creditor.
All right, this matter was set for 8:30 a.m. It is now 9:14. Mr. Stahl's failed to appear. He was served through alternate service. To a good address after multiple service attempts. He actually filed an answer. But he certainly has notice of the case. He's filed an answer. And the answer essentially is defense is, I didn't hire the doctors. He says, I didn't go to these doctors, but I'm assuming you have documentation that shows otherwise, counsel?
Yes, Your Honor.
All right, and I see there's a motion for summary disposition. Do you want to proceed by way of default, or do you want to argue your motion?
Your Honor, maybe just doing a default under the 7-day rule and trying him one more time if you'd like me to. If not, again, I defer to you. I ask that you consider our summary judgment. It is what you stated. He was the patient. He did see, doctors did see him, and he has not paid.
All right, I'm gonna go ahead and, I mean, it seems clear cut, but he did file an answer, he was served. We'll do the default under the 7-day rule and see if, Mr. Stahl responds.
Thank you, Your Honor.
All right, thank you, Mr. Burke, have a good day.
Great day.
Good morning, Mr. Royce. 318.
Good morning.
How are you?
Doing well. Just had to put my jacket on. I just pulled into a parking lot.
All right, well, you're not wearing a shower cap, so we'll give you some credit for that, Mr. Royce. I've got a few other people. I've got some other people. I'm gonna check in right now, okay? And we'll get you going.
Okay, sounds great. Thank you.
Thank you. Ms. Gertzberg, good morning.
Good morning, Your Honor.
Can you tell me what you're here on? I know you have a bunch of them, it looks like. 1273. That Mary Stitt.
Yes, and both William Atkins files.
All right, 5-1. All right, I have all those files and I have you checked in. So let me just see who else is here. We've got some people in the waiting room, okay?
Okay, thank you very much, Your Honor.
Good morning. I have Yvette Cloud in the courtroom. Miss Cloud, I have you checked in. Give us just a second. I'm checking in some other people, okay? You are checked in, ma'am.
Thank you. Good morning.
Good morning. And Jeanette Mitchell, good morning, ma'am. I have you checked in. I'm Velocity. Miss Mitchell, can you unmute and turn your camera on real quick? I'm out. There you go. All right. Hello, ma'am. And Mr. Royce, are you with me? Mr. Royce? All right, give me just a moment, Miss Mitchell.
Good morning.
All right, Miss Cloud, I'm just going to mute you, okay?
Yes, I'm here. I'm walking to a quiet area as we speak.
Okay, I'm just gonna press mute and you can unmute yourself when you're ready, but that way you can carry on until I call your case. And Mr. Royce, let us know when you're ready. I have the other party on your matter. Miss Bourne Fisher, you weren't gone for long.
Yeah, I didn't realize I was back at this court again.
I was gonna say, are you back for more?
Yeah.
Who do you have?
Bank of America.
Oh, versus Rachel Zawetti.
Correct.
Let me find that. All right, I've got the file. It was just a few minutes. I've got a few other people I'm checking in.
Okay.
Hi, Mr. Nager, good morning.
Good morning, Judge.
And are you on 0103 Midland Credit versus Vet Cloud Sewell?
Yes.
Okay. Are you related to Candace Nager?
I think I know who you're talking about. Is she young? Younger than me?
Yeah, she used to be she's a prosecutor. I don't know if she's still there.
Oh, I don't know. Then no, I don't think that. I don't know her. Then I know that I think another young.
Okay.
There's a lot of Nagers.
Yeah.
Yeah.
Okay, on your case, Midland Credit and Miss Cloud Sewell are both here. Would the two of you like a breakout room to discuss this matter before we call it officially?
Sure.
All right, Miss Cloud, I'm gonna put you in a breakout room with with plaintiff's counsel so you two can discuss this matter, okay? Okay, Thor Thorson,